With regard to item number 32, we have some difficulty today. I've taken consent from the other side from the petitioner. We have for respondents 2, 2, 3, 7, and 9, Coal India.
2, 3.
2, 3, 7, and 9, Coal India. After 3 weeks,
Do you have filed any response?
no.
No. 2022 matter.
No. Actually, we are going to file our reply within some time.
How much time within?
2 weeks, still.
Okay. Mr. A.M. Dr. Learned Counsel appearing for the respondent number 2, 3, 7, and 9. Has sought for and is granted. How much time? 2 weeks.
2 weeks, still.
To file counter affidavit on behalf of the said respondents.
Yes.
It is submitted that consent has been taken from the learned counsel for the petitioner to make the prayer. Post of prayer as the petition is of the year 2022. The respondents shall ensure that its counter affidavit is filed within 2 weeks' time. Place the case after 2 weeks on a date fixed by the office.
Most of this.
May I please, Your Lordship?
You are there. You are Mr.
For the petitioner, B. Sharma, right?
B. Sharma.
May I please, Your Lordship? Lordship, I beg to mention item number 43. Lordship, we are supposed to file an affidavit in reply. Lordship may grant us 2 more weeks for this matter.
Affidavit in reply.
I'm for the petitioner.
You are for the petition. In which item? In repetition or IA? IA.
Yes,
IA
Lord.
is for what?
There were some objection, Lordship. So we will be filing our objection against the
43.
respondents.
Who is for the applicant? You wait.
Lordship.
Yes.
Please, Your Lordship. Lordship, I beg to mention item 51. If Lordship pleases just to upgrade that matter, Lord.
No upgradation in this court. We will take up the matter.
The
29 and 30 of this case.
20.
29 and 30. I've taken the consent of the other side. I am the respondent in the IA malord in item 29 and petitioner in item 30. I have to bring certain additional pleadings on record. This matter may be taken up.
This
after.
IA is for what?
IA is for vacating a stay order.
It is listed for first time.
No, man, this is I think,
Then-
second or third. No, this is second or third time. Second time, I think. We have already filed our objection is already filed in there. So
Yes.
I have taken his consent because I need to bring certain subsequent developments on record for a short accommodation.
No, what kind of objection? This is for what? Vacation of the order.
The other petition is for admission afterwards. These are two connected matters.
Okay. On the prayer of Mr. E. Ganguly, learned counsel for the petitioners in WPC 2705/2025 and WPC 2171/2025 and opposite party in IC number so and so. Raise the case on so and so. Mr. Ganguly has sought for listing of the case on so and so in order to bring certain subsequent events on record by way of pleadings. It is submitted that consent has been taken from the learned counsel for the applicant in so and so to make the prayer. Is the case accordingly on so and so.
2907, 29 July.
Is the cases.
The interim order may continue.
The interim order, if any, past idea shall continue. To the
Okay.
next set of list.
May it please, my lord, while to the consent of the other side, I beg to mention item number 35 to 37 of the daily list, my lord.
Yes.
Our instructions are awaited in this matter. I am praying for 2 weeks' time to obtain it, my lord.
You are appealing for whom? Oil.
Oil India Limited on behalf of B. Gogoi, my lord.
Mr. Mishra, you have informed.
My lord.
Miss M. The learned counsel for the petitioners is present. Mr. H. Burua, learned counsel on behalf of Mr. B. Gogoi, learned standing counsel Oil,
Oil India Limited.
Oil India Limited has sought for and is granted. How much time?
2 weeks' time, my lord.
2 weeks time to file counter affidavits. The praise allowed is the cases on so and so.
3rd August 0308.
May it please, Your Lordship. Hello, I pray for adjournment item number 13 of today's day.
Item number?
13 of today's. I'll file an additional affidavit. It's first time in this motion today. I'll file an additional to support my case. May
On the
matter
prayer
come
of
after one-
Mr. N. Ajay, learned counsel for the petition, release the case on
After a week.
after which.
Plus,
22nd July, 2207.
With your lordship's kind
Consider-
permission, I seek to mention item number 47. Lordship, the petitioner is a widow who is going through a financial hardship due to the continued freezing of a bank account. Lordship, on the last date, due to paucity of time, the matter could not be taken up. And looking at today's heavy board also, I request your lordship. in the
No
matter-
objection. Next.
item number 10.
Yes.
One annexure, I have made a mistake. Instead of one, another I have
Hmm.
enclosed. So I may be allowed to withdraw with liberty to file a
Okay,
petition.
Mr. A. Aforesaid, learned counsel for the petitioner has submitted that due to an annexer, an important annexer could not be, an important document could not be annexed with the writ petition due to inadvertence and for that reason, he wants to withdraw the writ petition. The petitioner wants to withdraw the writ petition with the liberty to file a fresh. In view of the above submission made by Mr. Aforesaid, learned counsel for the petition, the writ petition is dismissed on withdrawal with the liberty as paid for.
I beg to mention one motion matter, my lord. Day after tomorrow.
What is the subject matter?
Subject matter, my lord, my furniture shop sealed without any notice, my lord.
Okay.
Lordship, may I pray for listing of a repetition tomorrow, Lordship?
Subject matter.
Lordship, no confidence motion has been, requisition notice has been issued against the chairman and vice chairman of a municipal,
When the meeting is to be held?
Lordship, tomorrow. Tomorrow is the last day.
When did you receive the notice?
Lordship, it was shown to be served on 24/6, but we received.
24/6.
Yes. We filed the writ petition on 29/6, but there was caveat and because there was.
So many vacation mentions were sitting.
Yes, yes. In fact, I made a mention also. But it was not listed because the caveat could not be served.
Okay.
That's all right.
Daily list for motion, item 1.
May I please, your lordship? This is a contempt case, my lord.
What is the order?
My lordship ordered page number 8, my lord.
Okay. Contractor bill,
My lord.
bench 4. Mr. D. Hussain, learned counsel for the petition has submitted that the subject matter of contempt petitions. Pending bill,
My lord, pending.
contractor bill
My lord.
pertains to bench 4. Registry to verify, the registry is to verify the subject matter and thereafter list the case before the appropriate bench.
Item 2 also similar.
Okay,
Similar.
2 is similar.
Highly obliged.
3. Item number 3.
Yes,
The order on contempt, your lordship will find at page number 10, my lord.
reviewing authority.
The relevant paragraph, page number 12, paragraph number 6, my lord.
Correct in heard, Mr.
MM Zaman, lord.
Jaman learned counsel for the petition first of this contempt petition is like alleging non-compliance of the direction made in an order dated 10/1/2024 passed in a writ petition WPC number 7213/2023. First of. But it is of 2024.
Lordship.
What did you do?
Lordship, I have served 2 legal notices, my lord, but as on date, no.
But that
response.
will, whether that will satisfy the condition of limitation.
Lordship.
What is the period of limitation? For filing a contempt petition? You sit over the matter for last 2 weeks, 2 years.
Lordship, it was forwarded on 29/1/2024. Page number 14.
Your
my lord.
notice page 15, 25/7/2024, almost 2 years,
There is a
almost 2
subsequent-
years.
There is a subsequent legal notice, my lord.
A legal notice will not extend the period of limitation.
I have visited repeatedly, my lord, but
whether that will extend the period of limitation for filing contempt petition. You satisfy me? What is the period? Two months.
lordship,
2 months means from January, March 2024. Then you served the notice on 29/1, page 14.
lordship,
Then thereafter you have been serving notices to them.
24 and another notice I have served on 22,
You
1,
satisfy me? In the face of section 20 of the Contempt of Court Act.
Lordship, I'll take instruction and incorporate the grounds of delay, Lordship.
No,
In that
grounds
case-
of delay, whether grounds of delay can be extended. Whether it can be taken cognizance of contempt of court act also. Section 20. No court shall initiate any proceeding of contempt, either on its own motion or otherwise, after the expiry of a period of 1 year from the date on which the contempt is alleged to have been committed. If I don't have jurisdiction, how can I initiate? Satisfy me. It is averted. The order dated 10/1/2024 was brought to the notice of the alleged contender on 29/1/2024. As per the direction made in the order dated 10/1/2024, the appropriate steps for necessary correction of the land records on the basis of an order passed in Miss Case number 59/2022 was to be completed within a period of 2 months from the date a certified copy of the order dated 10/1/2024 was served upon the alleged contender, that is the circle officer, Motia Revenue Circle, full stop. Meaning thereby, the alleged contemptuous act was completed on 10/1/2024, 10/3/2024. Full stop. A period of more than 1 year has expired since 10/3/2024. Full stop. In the above view of the matter, the contempt petition appears to be beyond the period of limitation in view of section 20 of the Contempt of Court. As on the Mr. Jamal has sought for listing of the case on Friday in order to satisfy the court as to whether the contempt petition is within the period of limitation. Friday, you satisfy me.
Lordship,
1707.
Other option is to file a fresh writ petition.
obliged.
Item 4.
May please, Your Lordship. One is a contempt petition. Following the notes findings at page 25.
Case 25.
25. The operative part at page
Let us
26.
6. Period prohibited facts following the petition is contesting a certificate of the. However, in December, the petitioner had made an offer to the bank to liquidate the dues. The state offer of the consideration was returned to the petition. Yes.
In substance, my lord, what the direction of the court, honorable court was that if I offer an amount of 20 lakhs by the next day to the bank, the same would be accepted by the bank and no coercive action will be taken for a period up to 28th July 2026. I must be fair, the matter was referred to mediation. Mediation did not fructify, but in between, I deposited 35 lakhs. Now, at page 28, during the operative period of the order of this honorable court that no coercive action be taken, conditional upon me depositing the amount.
No, after that, what happened on 27/4/2026? Where is the order?
My lordships.
Page 27.
No,
The
we have
case
not-
was to be listed on
Right,
27/4/2026.
it was listed. We have not annexed that order for the reason.
Why? Let us see the order.
We'll get it some other day. We'll have this matter. I'll get this order on record. Why we was ordered, we were making the payments. The matter went to mediation. Yes, I understand. We'll have it on record by additional affidavit.
This order was operative till the 27/4/2026. Thereafter,
This was
court will pass appropriate order.
This was in the second subparagraph, if lordship says. Last 26, the last part.
No, what happened thereafter?
I'll get it on record. It was referred to mediation, nothing new.
But the order is to be
Yes, I'll get it.
placed before the court.
Certainly.
When do you want?
Could it be on next month?
Okay, on the request of Mr. S. Monik, senior counsel, pending petitioner, lays a case on day.
20.
In order to file additional claims.
Only thing was
2007.
operational, they issued an order of taking vacation. That was a coercive action they have initiated. That's
The question is about SARFAESI proceeding.
the initial.
And regarding one-time settlement or something like that.
The issue was
Something like that, you have made an offer for settlement.
they invited for a re-offer. We gave that offer. Now they issued a notice. We came to.
And what is the role of the court?
Correct. I understand. Will get it.
5.
Short respite is different thing. Short respite is different thing.
So this was not.
In a matter of SARFAESI proceeding, an offer of settlement, rejection or consideration by the bank, how the court fits into that scheme of things.
We were on the point that.
And then thereafter the question of contempt.
Absolutely. We are only that we are not against the proceeding.
Let us have the additional ratings.
5.
Could it be listed along with the writ petition? We'll have it together.
No. We'll first see.
Item 5. Wait, please, Your Lordship.
Yes,
Judgment at page number 10 and relieving operating part is page 13. 1-3, paragraph 5.
supply bill.
Lordship.
Means for
Page 13, Lordship, paragraph.
Mr. Agordon, sir. Check number, item, appropriateness. Contractor bill,
Lordship.
means for
Item 6.
May I please, Your Lordship? My lord, in fact, we have filed an additional affidavit, my lord, on 26/6/26. My lord, that is not on record, my lord. We have verified. By way of that notification, my lord. In item number 7, we have filed it. And
In this item, Lordship, there is an order of 25/6/2026 whereby my learned senior friend is directed to file an addition to
yes,
bring on
that-
record.
That we have filed,
That-
my lord.
That is not filed in item number 6. So this is not.
similar is also 7.
Similar, item number 6 and 7 similar, my lord. So therefore,
Okay, you have already filed in
my
six.
lord, my lord, my lord.
Let us have this additional affidavit on record.
Acha, acha.
Then
My lord,
we'll see,
my lord, we have filed it in item number 7, my lord.
but that will not entitle the court to send this item.
Yes, my lord. We will file another one, my lord. File another one.
Why piecemeal?
The,
Both should go parallelly.
my lord, my apology, my lord, it's my mistake, my lord.
No, it's okay.
My lord.
Okay, let the additional affidavit be brought on record.
The notification is only required to, my
Ah.
lord, bring on, we have bring it, my lord. Subsequently.
But if a statutory notification
Yes, my lord, it is.
issued in exercise of statutory power, then it might have the same force as the statute.
My lord.
Is it not? Or what
Because
is the
my
law?
lord,
Yes, Mr. for Pujari.
Yes.
What is the law?
My lord, it was issued on in provision of this section 161, my lord.
It is 69 file করা না? এটা 60 লয়েছে, 7 to
পঢ়ি আছে নেকি এফিডেভিটত? ইমান কৃপণালি কিয় কৰা? কেন কপিও নাই?
A notification issued in exercise of statutory power, whether it has the same force as the statute.
My lord, that is because my lord, it is
If
issued in.
it is the law,
It is the law, my lord.
then in that case, this court might not have the jurisdiction to take cognizance of such repetition.
My lord.
What do you say?
Lord, I have the notification is issued in pursuance of the provisions of chapter 10.
Chapter 10,
Yes.
perhaps section 160.
Absolutely.
161.
161. So that is the enabling provision under which, my lord, these notifications are issued.
Right.
Because it has, my lord, at the end of the day.
The question posed by this court is that a notification issued in exercise of statutory power, whether will have the same force as of the statute,
Yes,
Yes, yes.
right?
yes,
If that is so, then it is part of the statute.
part of the state.
Then if the virus of that is challenged,
Yes,
whether a single bench has the jurisdiction or not,
yes.
Lord, generally,
Yes.
as per roster, it is.
show us by from the High Court notifications and
Yes, yes. Also bring that on.
so that I can say that I don't have the jurisdiction.
My lord.
Or otherwise, I have to make the research.
No, no, my lord, we will try.
I'll say that court takes 2 weeks time to make a research because court counsels are not assisting the court.
No, no, my lord, we will definitely assist.
One decision, lordship, is well aware, my lord, of the Rajiv
Rajiv
Goswami.
Goswami.
Huh?
In Rajiv Goswami, that is a decision of this honorable court, wherein, my lord, there also in that matter, that notification was put to challenge. And this honorable court was pleased to negate the contention of the, my lord, petitioners.
Show us that
and
Rajiv
upheld-
Goswami.
Rajiv
Whether that virus was challenged.
No, no, no.
No, see, there are two things.
Virus was not challenged.
Then
It was a mutation.
if virus is not challenged, I can proceed. But here his prayer is, first prayer is,
Yes, to set aside that notification. So therefore, my lord,
now whether he has challenged it procedurally or substantively, we don't know.
yes,
But his prayer is,
Lord, my prayer is to exclude our villages, my lord. Basically, that is the main prayer, my lord, because we,
therefore he
My
admits, he admits.
modify.
my lord. Because, my lord, by
What is
the
now? Second prayer, second to sound.
6 and 7. 7 to be.
Where it is set aside, I have seen it, page 60 in the second one.
My lord. 60, my lord.
Alter or modify.
alter, modify the impugn notification number so and so dated 27 to 1950.
7, item number 7.
In the second one.
In first one also the same prayer.
No, alter or modify
Yes, in
by
item,
excluding the village of the petitioner.
in item number 6, lordship, the first prayer is alter, modify the impugn notification number RD so and so dated 27/02/1950 by excluding the village of the petitioner, namely so and so.
So what is the difference between the two, Mr. Punya? Please enlighten us.
The difference we have, my lord, the first, my lord, that the, as the area wherein we are residing, my lord, is required to bring under the notification if the area is predominantly occupied by, my lord, the class of people who deserve the protection, my lord. But from our research or the various survey reports, my lord, which we could gather.
Now, as a senior
collect.
counsel, please apprise me whether
My lord.
Item number 7 is of the single bench jurisdiction or division bench jurisdiction? Item number 7.
No, my lord, item number 7, page number 60, my lord. If we go by prayer, my lord, from my limited knowledge, it should go before the division.
And what about item number 6?
6 is, my lord, because it is not the directly challenging the order, my lord. It is just, my lord, asking for a mandamus for exclusion of the, my lord,
So
the area. my
whether
lord.
this court will have jurisdiction
My lord,
to
in-
set aside a part of the notification?
No, my lord, if the notification is required to be interfered with, my lord, then it is required to be adjudicated by the.
So as a
division
senior
bench.
counsel, please apprise me whether these two can be taken up. Item number 7 is division bench, and by some arrangement of words,
My lord.
item number 6,
My lord.
whether this can be taken up by single bench.
My lord, I think it is as the notification is required to be interfered with, my lord, the area, then, my lord, I think it is required to go before the.
One is fully, one is partial.
Partial.
So
But
therefore-
the
so
target is same, my lord.
So therefore, admittedly, my
Fine.
lord, in both the repetitions, he is calling upon this honorable court to interfere with the notification,
Fine.
which only the division bench is empowered.
There are schemes in the Gauhati High Court rules and provisions where notification is challenged, which code, which this thing, please apprise this code.
My lord, I will,
Earlier I made a research, I forgot.
My lord,
my lord, I will. In the meantime.
Heard Mr. A.R. Bhuyan, learned senior
Fine.
counsel for the petitioner. Petitioner's item number? Single petitioner.
Yes, my lord, in
Okay,
one single
petitioner.
petition.
And Mr. R. Bopuzai and his pending counsel revenue department. And Mr. H. Sharma, additional senior government advocate for the state respondents. Mr. Punya has submitted that an additional affidavit has been filed by the petitioner on 26/6/2026 in order to bring on record the notification
Dated, my lord.
dated 27 to 1950, which the virus of which is challenged in the writ petition. First of however, the said additional affidavit is not on record. First of in view of the same, as the additional affidavit, stated to have been filed on 26/6/2026, is not on record, registry to trace out the same and bring it on record. Post of release the case on so and so. Friday. Next, item number 7. As sought for by the learned counsel for the parties, release the case on Friday.
1707.
Come up with that code.
Yes.
Yes, yes. Chapter 5A, Rule 2, so far as I remember. Yes.
Find out.
Yes.
Item number 8.
We'll try on the end of the list. With time permits, with the immediate folder.
Item 9.
The assessment and appeal order, Lordship, the issue is covered by the order passed by this honorable court. In the case of National Plasto, Lordship, the issue is that when the selling dealer has not paid the tax to the government, my ITC as purchaser was denied. Against that, Lordship.
These will be factual aspects.
Lordship.
These law is settled.
Law is settled, Lordship, that.
But whether they uploaded or not uploaded, whether you are entitled or benefit, these are factual aspects. Law is settled.
That factual aspect.
Why should we enter into that when your appellate remedy is available?
Appellate remedy I have exhausted, and they have said that against the National Plasto judgment passed by this honorable division bench of this honorable court. They have said that it is not applicable because the selling
No,
dealer has
what
not
appellate
paid tax.
remedy you have availed?
I have filed appeal, Lordship.
107. 112 is still available.
Lordship. But when Lordship, when it is clearly against the provision of law settled by this honorable court.
Where is the appellate order?
Lordship, appellate order is on Annexure 5, page 80 starts.
Annexure?
Then Lordship may turn to page 98 where this High Court order I have referred to has not been complied, Lordship. Lordship will come to fourth paragraph. The appellant also contends that the ITC cannot be denied to a bona fide recipient merely because of the supplier default in not tenable in light of the binding judicial position laid down by the Gauhati High Court in National Plasto Molding Private Limited of the State of Gujarat. In the present case, the appellant has failed to discharge the burden of proof cast upon him, having not produced essential documentary evidence such as original tax invoice, proof of actual receipts and movement of goods, corresponding bank transactions, evidencing payment to supplier, and any credible material to establish that tax charge has been actually paid to the government by the supplier. Lordship, these all documents are within the custody of the supplier. How can I prove that he has paid or not paid? He has not filed his return, because of which I have been denied the ITC. And what is finding in National Plasto is that the department has to follow with the supplier and catch hold of him for recovery of the taxes, Lordship. Therefore, the ratio of the aforesaid judgment which applies in case where the recipient has established due diligence and fully fulfilled statutory conditions cannot be extended to the appellant. The recipient is the Lordship, the seller. He has received the taxes and he is supposed to pay.
No. Original tax invoices.
Lordship.
You don't have the original tax invoices. You have
Yes.
proof of
Produced
actual
along
receipt
with the-
and movement of goods.
Lordship, that I have. I have
And that
produced.
you have
Yes.
corresponding bank transactions evidencing payment to suppliers
Yes.
and any credible material. Lastly, but other things you have, but you have not laid the factual foundation.
No, Lordship.
That is what it says.
But those have been, Lordship, then how come he came to my turnover?
Sir,
Came to my turnover.
original tax invoices.
Lordship.
Law is set. That does not mean that you have to do away with all the factual foundation.
No.
Original tax invoices. See, having not produced essential documentary evidence such as original tax invoices, which you have, proof of actual receipt and movements of goods, you are the recipient of goods, corresponding bank transactions evidencing payment to suppliers, it is your job
Lordship.
to present those.
Yes. That I am satisfied, Lordship. Because based on the return.
That is what it says. Read again. Let us read again.
In the present case, the appellant has failed to discharge the burden of proof cast upon him, having not produced essential documentary evidence such as original tax invoices, proof of actual receipts and movement of goods, corresponding bank transactions, evidencing payment to suppliers.
Suppliers.
Lordship.
It is your job. You are the buyer.
Yes.
So you did not lead that factual foundation.
That is part of the Lordship. We have produced, Lordship.
Then go to the appellate authorities, show that I had laid factual foundation, but first appellate authority did not consider it. Writ petition is not the panacea of all ills. Appellate authority has clearly stated that you have not laid the factual foundation to apply the law laid down by National Plasto. That is the case. And that is why the court bench has observed that section 112 of the Act categorically mandates that an appeal lies to the appellate tribunal. Lead the evidence before the appellate authority.
Lordship, those evidences were produced before the appellate authority, but this
That is not a ground for filing a writ petition.
No, that is
Law is settled.
Law is settled.
National Plasto.
Lordship.
And there are other decisions of the Supreme Court also.
Lordship, so production of these documents are concerned, because based on those documents only, he has determined my turnover. Based on those documents, he has determined my turnover. How come the assessing authority will determine my turnover? Based on the return and the documents produced. So he has determined it. So it is no question that I have not produced it. Other than that, how can assessing authority determine the turnover, Lordship?
Now, where is your memo of appeal, sir?
Memo?
Memo of appeal?
Memo of appeal, Lordship, I have not annexed here. I have annexed only the order, Lordship.
You will be running the risk dismissal of the petition if this factual premise is not laid in the appeal.
Lordship.
Then thereafter no second appeal. I'll foreclose everything. If this is the ground on which your appeal is dismissed, you run the risk of foreclosing everything. I'll direct the authority to bring the appeal memo on record.
I can bring the on record, Lordship.
I'll direct them, since you have not. But thereafter, you run the risk of foreclosing the option of filing the second appeal.
Lordship, because
If this is the ground, because an appeal, it is not that you are the appellant. You have to stand on your own feet.
Lordship.
Don't shoot the,
No, I'm not.
that everything is available. I don't need to have to make my grounds of appeal. I simply file an appeal. It is their burden. Factual foundation not laid. That is the ground. That is what I am asking for. As simple as that.
Lordship, I may be granted opportunity. I'll try to.
Okay, bring the
record.
appeal memo on record.
I'll bring it.
Who is the other counsel?
On behalf of respondent number one.
So what do you say? That is not the way to be present in the court, just for the sake of appearance. Where is Mr. Kyle? He is not available.
Is not available, Your Honor.
Dr. A. Todi, learned counsel for the petitioner, has sought for his time to bring the memo of appeal filed by the petitioner before the first appellate authority on record by way of an affidavit. Release the case on Monday.
Much.
2007.
Item 11.
Please, Your Lordship.
Yes.
Account freezing case, Your Lordship, which has been done without any notice. There are two alleged transactions of 5,000 and 7,000. I have only been intimated verbally, Your Lordship, but has not been produced any.
Heard, Mr.
Key Dekha, Your Lordship.
A. Deka, learned counsel for the petition. The petitioner has been maintaining savings bank account number para 5 with the respond number 2. First off, it is stated that on 30/01/2025, the account showed a balance of rupees 2,04,675. Full stop. Para. It is a case of the petitioner that the said bank account has been debit freezed by the respondent number 2 on the premise that cybercrime complaints is received regarding 2 suspicious transactions, stroke credits amounting to rupees 5,00,000 and rupees 7,000 respectively. Full stop. Since when?
Since Lordship January. Lordship.
Since January 2020. Issue notice returnable on such. Counter for the petition. Shall serve a copy of the petition along with annexer to the Deputy Solicitor General of India for service of notice within 2 working days from today for service of notice after the response number 1. The petition shall take steps for service of notice after the response number 2 by registered post into by speed post.
1408, 14th August. Item number 12.
Yes.
Lordship. The father of the petitioner was my lord Rayat under the original Patta Dharma. Lordship will find page 13 is the Khotian was issued in the name of the father. Thereafter, my lord, after the death of his father, in the name of the petitioner along with other legal heirs, the Lordship will find.
So you are aggrieved by non-disposal of tenancy case. Will issue notice? Heard Mr. S. Nath, learned counsel for the petition. Since when it is pending?
25 months. Notice your Lordship at first.
Yes, Mr. District Commissioner Kamrup.
Yes.
We can have a try regarding the status of this tenancy case 2023.
23, yes, my lord. Notice.
It is not a recent origin. Within 1 week's time, you can get the instruction about the status. Ms. Ann Bordole, Standing Counsel, Revenue Department for the respondent number 1, and Mr. H. Sharma, and additional senior foreman advocate for the respondent number 2 and 3. The petitioner is aggrieved by non-disposal of tenancy case number 4/2023, which is pending before date first of. It is the case of the petitioner that the stake is the proceedings of tenancy case number so and so. Yes, for the purpose of ownership right in favor of the petitioner as the applicant under section 23
Yes.
of the Assam within bracket temporary settled areas bracket closed tenancy act 1971 closed up. As tenancy case number so and so is stated to be pending since 2023. Mr. Sharma, and additional senior government advocate shall obtain instruction regarding the status of present status of the same case. As sought for by so and so. List the case on next Wednesday.
Lordship.
Mr. Nath, and counsel for the petition shall supply a copy of the writ petition along with annexer to Mr. Sharma by tomorrow to enable Sharma to obtain the same.
2207. Item 14.
Yes, madam. File an application RTI. Taking the district eliminate issued intimation to the petition to collect information from the proprietor. If files you heard that you there of the second appeal to the respond number 2.
Standing counsel is there for some information coming.
They have to this is to pass an order. Where is that order? 29/10/2025. Page 30.
Property part, Lordship, is at page 33, Lordship.
Heard Miss
F enters.
Learned Counsel for the petitioner and Mr. H. Sharma, learned additional senior government advocate.
Yes,
for
ma'am,
the
number
respond
one.
number 1. 1. Full stop. Miss the land counsel for the petitioner, self furnish. Sells a copy of the reputation along with annexa to Mr. D. Deca.
D Deca.
D.
Deputy
Deca,
Deca.
Land State Standing Council, Assam Information Commission, by tomorrow. Full stop. List the case on Friday, reflecting the name of Mr. D. Deca, Land Standing Council, Assam Information Commission in the respondent side that call list.
Item number 15.
Yes.
My lord, this is regarding, my lord, property, my lord, mutation of property, my lord. We had raised one objection before the circle officer Dhikia Joli, my lord. It is at page 130, my lord. Kindly have. May I read, my lord?
You have filed an objection.
Yes, my lord, that has,
It is before circle officer.
yes, my lord. No hearing,
And we have to direct, issue a mandamus to consider the objection petition.
no, my lord, no hearing has been given till date. No hearing has been given till date, my lord. Since last 5 years,
Last 5 years.
my lord. 21, we had given the representation, my lord. End of 21, my lord. 28/12/21.
What is the mutation case number?
My lord, the mutation case number, my lord, filed by the private respondents, my lord.
No.
Yes, ma'am.
Obviously.
Yes, ma'am. My lord, may kindly have page 7 of the repetition, my lord. I'm reading. Mutation case numbers 1-777-21 and 1-777-22. Filed by the respondent 5. my lord.
Mutation case number so and so. Para 5.
Para 7, my lord. Page 7.
Para
of the-
7.
Para 7, page 7. Annexure is also there, my lord.
No, where is the case number?
Case number page 127, my lord. Page 120.
Where have you mentioned case
My-
number in para 7?
Para 7 I have mentioned, my lord. It is been
Which one?
para 7 last portion, my lord. Page number 7, para 7.
Huh?
Yes.
Last but 3 lines.
Last 3 lines.
Where is the case number?
Case number 9.
My lord, these are the application numbers, my lord.
Case number
Case number 9.
Case number, my lord, this is all the only information.
See, if no mutation case, if the application has not been registered as a mutation case, then where is the question of consideration of your objection?
My lord, if my lord kindly goes through the Jamabandi also, they have already started the mutation processes, my lord. They have already started taking the. That is the problem, my lord. Without.
No, question is regarding with your prayer. See, you are seeking a read in the nature of mandamus.
Yes.
That authority exercises original jurisdiction. Right?
Yes.
And it has its own ambit and scope of jurisdiction.
Yes.
And you are seeking a writ that for directing that authority to consider your objection. Is it not? If that authority does not consider that objection, yes, question of issuing a writ in the nature of mandamus will arise. Right? But a direction at this stage is not, would amount to interfering with his original jurisdiction.
My lord, no due consideration has been given as my
No,
lord.
Mister, you have to know the scope of jurisdiction,
My lord.
re-jurisdiction.
My lord.
If we go on interfering with the jurisdiction of the original authority at the time of considering exercising his original authority, that amounts to interference. If he does not consider, yes, while exercising his original jurisdiction, if he does not consider relevant factors or takes irrelevant factors into account or acted beyond his jurisdiction or acted in ignorance of his jurisdiction, yes. But at the time of exercising, that direct him to consider your objection, that is an issue which is not within the scope of rejudication. That is why I am asking where is the mutation case number? From where you are saying that some actions are taken on the basis of those applications.
My lord, no, my lord, the application is only available with us.
Application is available does not mean that he has exercised the jurisdiction. What steps he has taken, the original authority?
My lord,
What step he has taken on the basis of those applications?
my lord, with regard to that, my lord, sometime may be given. I will find out the status of those applications.
No, after filing, Mr. You are Mr. Sharma. After filing, don't go for fishing inquiry or investigation. First, you make the investigation, inquiry. Then you file the writ petition. You first file the writ petition, thereafter, okay, give me 4 weeks time to find out what is going on. This is not. Don't waste the judicial time of this court. What steps he has taken? Circle officer.
That is our grievance, my lord, in the case.
No, firstly, it has to be registered as a mutation proceeding. Then the question of filing an objection, issuance of notice. Then thereafter, filing of objection will arise. But if he has kept it inside the almirah, why should we enter into that aspect? Have you understood, Michael?
Yes, my lord. Sometime may be given, my lord.
No, sometime.
Because one objection.
Come up with better particulars. I will not object to that. But it appears to be premature.
My lord, may I
Without the necessary details. Let us read your whole entire writ petition. Yes, Mr. Sharma.
Lordship. Most probably in paragraph number 7, these are the applications number, Lordship. From that this application word is missed in this typographical.
Some mutation case has to be registered.
It has to be registered. I have seen the annexure 6 at page 127. These are the application
Annexure
number.
6.
Annexure page 127. Then Lordship may kindly come to page 128.
For copy of Jama. These are application for copy of Jama.
Yes.
Theta.
Here this 1777722 number is one at page 128. This number is
That paragraph 7.
yes.
That word application.
Why this number is put here, Lordship, I do not know.
Mr. Sharma, I am dismissing your reply. No point.
My lord, may I take the liberty to withdraw my?
It is up to you. I'll come up with better particulars. And don't ask for this kind of mandamus.
Was only on the natural justice part, my lord. My mistake, my lord. I was only on the natural justice part because no hearing, nothing has been given since last 5 years. We've been kept in a limbo, my lord.
When no proceeding is initiated, where is the question of natural justice? You have to show us that mutation on the basis of those applications. From what Mr. Sharma has shown, it is an application for copy of the chitha.
Lordship.
Heard Mr. P.R. Sharma, learned counsel for the petitioners, Mr. A. Sharma, learned additional senior government advocate for the response number 1, 3,
1, 3, and 4.
4, and Miss Ann Bodo, learned standing counsel, Revenue Department for the response number 2. So after hearing the learned counsel for the party, the some like Mrs. Sharma, learned counsel for the petition has submitted that the petitioners may be allowed to withdraw the petition with the liberty to file afresh with better particulars. First of in view of the above submission made by Mr. Sharma and for the petitioner, the petition is dismissed on withdrawal with the liberty as prayed for. Come up with better particulars and better prayers.
16.
Yes. Hmm?
My land has been acquired by the National Highway.
Your land has been acquired.
Acquired, but
Okay.
on the acquired land, my poultry farm is there, Lordship, but that has not.
Under National Highway Act.
Yes, Lordship.
Where is your the notification page 20?
Notification.
Where is your land?
Lordship, page 22,
Page 22.
serial number 599,
Serial number
599.
599.
Bottom, Lordship, will find 77 plot number, that is dark number, Lordship.
Dark number 0.0058 hectare.
The second notification, the 3D notification subsequently issued
Just a minute. This is what notification?
3A, first notification.
No,
Yeah.
not 3A.
Page 22.
Then it is required. 3A.
3A, Lordship.
Okay.
Then second notification, Lordship, page 23. At page 25, serial number 114.
Computer receive objection. And person also has submitted his report. After received. This is 3D1.
This is
Declares.
3A,
This
first
is,
one, page
should
20.
be
Page
acquired.
23, notification.
Therefore, have declares 3D2.
Lordship. Page
Okay.
Page 25, serial number 114, Lordship.
Page 25.
Serial number 11477.
114.
Lordship, right side will, Lordship will.
Jorul
find
Islam.
Jorul Islam in place of Jamrul Islam. Son's father's name is correct. Then I request that for correction of my name and also not assess my value. According, they corrected my name, Lordship, Jamrul Islam. But my where there is a poultry farm that has not been assessed. That is my prayer, Lordship. Repeatedly requested also to include the poultry farm.
Poultry farm.
Poultry farm, Lordship. Then I submitted representation also, Lordship, page 26. They have not been considered. 26, Lordship. Subject resurvey of land, patta number 2nd as per number 41, tag number 77.
78 is not taken.
I am not 70, only 77.
Only 77.
77, Lordship.
Your poultry farm was there.
What was the other? I mentioned, Lordship, in my representation also, Lordship.
Yes. Yes, Ms. Barma.
Lordship, firstly, that a representation is submitted to the Deputy Commissioner, my lord.
Yes.
Though it is mentioned as through a
Through-
Kasar, my lord.
Ah.
So probably competent authority. Second one is, my lord, if he is being, his farm is being left out, then I think clause of arbitration will come in, my lord.
Arbitration come thereafter, lordship, but assessment is
Once
required
3D
thereafter.
has, 3D has already been published, my lord.
Let us see his representation.
Lordship. Three D, 3 0, no. 3 0 to status full overlay going to meet and
What is the amount you have received?
I have not received the land till today, lordship.
Huh? Compensation you have not
Compensation
received.
not received.
Then we
What
need
is
to
the
take
quantum of
instruction.
compensation?
3 0.
Not for-
3 0 is
But
not
it is-
mentioned.
it-
Probably
it-
it is not come up, my lord. Declaration is being made by law, but 3 0 may not be published as yet, my lord. Global status. to global.
Any poultry farm registration?
Lordship.
State license?
Trade license, village area, not actually required.
Panchayat?
Lordship.
Panchayat permission?
Panchayat permission, the ship house.
Show us something.
Permission
Because in
is-
two of the cases, I have said, as soon as the 3A notification comes, everybody started construction hurriedly.
No,
But
lordship, no.
it came out
No.
in satellite
Page-
image.
Page 18,
Nothing.
lordship.
You were there, huh?
Yes, two
Page-
cases.
page-
And there was no existence of any structure. Suddenly, after 3A, everything
This
started
belong to
It is
same
not.
district. my
with
lord.
bamboo and so, and claim is made.
To that
Iron
extent,
structure,
Supreme Court
poultry
has a-
farm, everything.
Kindly see
Supreme Court
page
has also-
18 and page
Interferes.
page 19 also, lordship.
19.
Page 18, water connection.
Zamrul Islam.
Yes, page 16 is the my permission for construction house, lordship.
Construction of house.
Lordship. Lordship, I am paying taxes to the Panchayat department
For what?
regarding my house, lordship, house taxes. And pay water connection is page 18, lordship. Where are you?
House has not been assessed.
Not been assessed. Lordship. And water connection I have also annexed, lordship.
House tax.
House tax. And page 18 is
No,
lordship,
PG has not yet come.
water supply and center.
Suppose.
PG has not yet come.
But-
One is land compensation.
Land
One
company.
is Zirat compensation.
What will
Only
be
Jidat
the
If
If
you
that's
have
difference?
these documents, house tax you are paying,
Lordship.
it has not been published yet.
As per the
Let us have
Have
the
Inspection first.
instruction first.
Yes,
No point.
lordship. Maybe a premature one.
Maybe a premature one. If your house is included there,
lordship, since notification has been issued.
poultry
lordship,
business,
that
I don't
as
know.
per the
Poultry
page-
business, I don't know, Mr.
Lord.
Bhuya, but so far as
House is
existence of
concerned.
house is
My lord,
concerned,
It has to be assessed. now.
it
that
has to be
That is
assessed.
required to be assessed.
We
lordship.
have not been able to show any poultry thing.
My lord, poultry farm, that's, I have a house here.
See, Mr. Bhuya,
Yes, particularly not mentioned.
see,
in
Mr.
poultry farm.
Bhuya,
Lordship.
if you are running a poultry farm consists of how many chickens?
Lordship.
Show us some photograph, your photograph with 100 chickens.
Chickens, lordship.
House I
Chicken,
can-
I will be removed, lordship. More
Huh?
question, they may.
Show us
house
the
have
photograph of the
damage.
house.
At least house.
Photograph of the house.
I have not annexed, lordship.
Please enclose us.
Lordship.
Please enlighten us.
Next date I will put place.
Better
Lordship.
that you have a RCC house or Assam type house or Tetchet house, whatever.
Lordship. Next.
Then I can ask the competent authority,
Next
Kala,
date, lordship. Yes,
whether you have taken
yes.
this into your survey or not. But show us something.
Yes, lordship. Next day I will place the photograph. In the meantime,
Because it has not, position has not been taken. So your house
yes,
has not yet been demolished.
If in the meantime demolished,
Please.
if they demolished,
He has he has a mobile. Ask him to take a photograph of his house today itself.
Yes.
Because I have found out, at least in 3 of the cases, all constructions are imaginary.
But here is no, sir.
After 3 notifications, everybody started for hurried construction, thatched house, whatever. Then escalate the price with the revenue staff official, which
matter
is constructed at
went to
10,000,
Supreme Court
asking
also.
for 2 lakhs. So give us the photograph.
Yes, I will place the
Heard
photograph.
Mr. F.C. Borvian, learned counsel for the petitioner, Mr. Postop. Mr. Borvian, the petitioner has stated that a plot of land measuring 0.00 base 25 0058 hectare falling under tag number 77 at village
Sikona Part 2.
Sikona Part 2 has been acquired by the central government and by the Ministry of Road Transport and Highways, Government of India, under the provisions of the National Highways in 1956. And a notification to that effect under section 3D within bracket 2 of the NH Act 1956 was issued on 15/3/2024. Full stop. The petitioner has not stated as to whether any award under section 3Z within bracket 1 of the NH Act has been passed or not regarding compensation. Full stop. It is a case of the petitioner on the said plot of acquired land. The petitioner had a house constructed prior to the issuance of the notification. Dated 12/2/2024 under section 3(1)(a) within bracket 1 of the NH Act. And the Zirat during survey, the said house has not been taken into consideration. Full stop. Para. Mr. Borhuyan has sought for a week's time to bring a photograph of the said existing house on record as till date the possession of the acquired land has not been taken over. Release the case on suits. 1 week. Release the case on suits for the filing of the additional evidence.
22007.
Number লিখেছে আমি দিয়া না নাম্বার দিয়া নাই এফি বরভূঞা petitioner Mr. S. Kakoti, Central Government Council for the response number 1. Ms. N. Bordoloi, Revenue 2. Panchayat, why Panchayat has come? M. Borhuya, sorry, M. Bormon. M. Bormon. Junior Government Advocate. Assam for the response number 4 and 5. NMS R. Bora, Standing Council. NHIDCL for the response number 6. 6. Any panchayat?
Panchayat name is not shown.
Post of. At least the case also. And probably put the name of the Land Standing Council, Panchayat and Rural Development Department be reflected in the respondent side the columns.
22nd July.
Photograph.
Item 17.
May it please your lordship. The petitioner has filed an RTI application before the Public Information Officer of District Agriculture Officer, Sipsagar, dated 10/12/2025. We sought some informations regarding HM, NEH, NFSM apart and RKBY scheme for the year 2020, 2021 and 2022. And
Okay, you serve a copy to Mr. D. Deca, Standing Council, Assam Information Commission. We'll take up there. Or Mr. SRA Nasir. Land Council for the petitioner. Miss. Agriculture, Miss R. Bora, Land Standing Council. Agriculture Department for the respondent number 1, 2. Miss M. 5 also.
5 also. 5 also.
M. Bormon, Lieutenant Government Pocket for the respondent number 4. Post of Mr. Nasir, Lieutenant Council for the petition shall serve a copy the petition along with an excerpt to Mr. D. Deca, Land Standing Council, Assam Information Commission for service of notice upon the respondent number 2 by tomorrow. Post of release the case on Friday. Post of the name of Mr. D. Deca, Land Standing Council, Assam Information Commission is to be reflected in the respondent side.
1707.
deeply.
Item 18.
Lordship, matter is pertaining to availing of income tax credit, Lordship. GST, Lordship. Lordship, the petitioner firm, Lordship, had purchased medicines, Lordship, from the seller, Lordship, by proper
What
invoices.
kind of proceedings? First, apprise about the proceedings.
Lordship. Proceedings started with Lordship, issue of Lordship, so-called notices, Lordship.
When?
That's on page 40, Lordship. Exit 3, Lordship.
Under section 73.
Lordship.
Okay. Then
Lordship.
order.
Lordship, we had.
Order under section 73.
Lordship.
Page 45.
Lordship.
What is the demand? 6,83,088 for the financial year July 2017, March 2018. Summary of the order. That was in 2023, 8/12. Then what happened?
Lordship.
You filed appeal.
Lordship, we filed appeal, Lordship. While filing the appeal, Lordship, we had also submitted, Lordship, from our seller, a document, Lordship, which they stated.
The appellate order, 30 December 2024. Yes, appellate order. Then 30 December 2024. What did you do? Page 55.
Lordship, they sent this order by WhatsApp, Lordship. After about 1 month, Lordship.
This is page 55 is of 30 December 2024.
Lordship, we didn't get it in time, Lordship.
What have you stated?
Lordship, in the petition itself, we have stated,
Let
Lordship.
us see.
What is the number? Annex Akiman Asula. It will annex Akiman Asula. Annex Akiman Asula.
Where is that?
Lordship, page 16, Lordship. Para 16, Lordship. Subsequently, they had filed, so-called filed.
No, when the appeal
Yeah.
order, when the appeal order, that appeal page 55, where have you stated that you have patched up all this? Because paragraph, from paragraph 12,
Lordship.
you have said that in spite of placing all documents to the satisfaction of the petitioner, the appeal filed by the petitioner was rejected and dismissed. An original order has been appealed.
Lordship. No,
Now, in this writ petition, you are challenging what?
Lordship, the last page, Lordship, last order, Lordship. Cancellation of a registration, Lordship.
Let us see your prayer. Show cause notice, order, original order, order in original, order in appeal, and suspension.
Lordship.
Which one is your preferred?
Lordship, at this stage, Lordship, the registration, because I could not continue with my business, Lordship.
Registration is a natural consequence of the order in appeal.
Lordship, that is there, Lordship. But Lordship, there is several Supreme Court orders, Lordship, which says that if the seller defaults in making the payment, Lordship.
That will come later on.
Lordship.
Question is about order in appeal
Lordship.
was an appealable order.
Lordship. Lordship.
112.
Lordship.
3 months was the period for appeal.
Lordship.
And condonable by extended period of limitation is 1 month perhaps. No, 1 month. And you did not prefer any appeal.
Lordship. That is there, Lordship. I also got it at the last moment, Lordship. Then.
Three months. Then subsection 5 perhaps. 3 plus 3, 6 months. That expired in June
Lordship.
2025.
Lordship.
Meaning thereby those orders attain finality. The question is that whether those orders can be examined by this court in re-jurisdiction.
Lordship, I have to go through it. Lordship.
Because Supreme Court also says that when an appeal is, this is a special enactment where by virtue of section 29(2), section 5 of the Limitation Act will not apply. Right? Now, if the normal period of limitation and extended period of limitation, that is 3 plus 3, 6 months, expires. Supreme Court says, don't exercise re-jurisdiction. Supreme Court says, neither Article 32 nor Article 226 can be exercised to condone any delay. Do not to speak of, they said even Article 142 cannot be exercised, not to speak of 32 and 226. In such situation, whether this court will exercise a writ.
I was not aware, Lordship. I have to go
Think it
through
over.
Lordship.
I give you time because our hands are also tied because this is held to be repeated judgments.
Lordship. I have to go through.
Supreme Court, even after exercising power, they have withdrawn. When the point of limitation was raised, Initially motion they permitted, but at the final hearing say that we did not.
I have to contact my client also whether they have done anything.
That also have to.
Find out. If they have done anything after the appellate order, that can be taken note of. But if you are sitting tight after the appellate order for doing nothing for last 1 year and allow the period of limitation to expire, thereafter, suddenly, on one day, let us file a writ petition, avoiding the deposit, pre-deposit of the demanded amount. Appeal requires pre-deposit. Let us avoid that. Wait, then file a writ. Supreme Court has, our hands are tied. Find out, heard Mr. Manoj Bhanabal, M. Bhagavatil and conservative petition has sought listing of the case on when?
2 weeks.
Next Friday. This Friday, next Friday. Also, in order to complete his instructions. Who is the respondent counsel? The learned standing counsel. Finance and Taxation Department. Government of Assam
Government of Assam.
is found absent today on call.
2407, 24 July. Item 19.
My lord, Mr. Chaudhary was supposed to appear in this matter, my lord. Kindly take it up at 2, my lord. He start for medical checkup, my lord. At 2.
After motion will call up. Thereafter, at the end of the list.
Item number 20.
Make this your motion. Essentially, there is a delay in approaching this honorable court.
Delay.
19/2/2022, the Real Estate Regulatory Authority passed an order, which was an inter-party order.
Inter-party.
Inter-party. Today, we raised a question that it lacked jurisdiction in passing what it had done. And this bona fide, it was quite bona fide that none could see through it. Even we also approached this honorable court earlier. May I invite my lord's attention to the order, which starts at page 16.
I am putting this again question. There is an appellate authority. What was the period of limitation?
30 days.
It was an inter-party order. Did you approach the appellate authority?
We had approached the appellate authority for extension of the time of 45 days, but that was not exceeded to. We filed a writ petition. My lord was pleased to bring the writ petition, my lord.
Appellate authority approached.
We had approached.
Yes.
That order, my lord, finds at page 37. Lordship had passed the order. And even at that point, this did not occur that the jurisdiction part was wrong.
Approach this provided the region.
So, wait a second.
Proposed to be submitted.
No, 60 days appellate time was there, but direction was for 45 days to pay up. On that question, we had moved. Twenty-four 6
So your petition was dismissed.
Yes, it was on the premise, and quite fairly, we did not see to the point that jurisdiction error was there, absolutely lack of jurisdiction. We prayed for extension of time in terms of the limitation period, the direction was for 45 days. On this, Manoj was pleased to take new pick, and accordingly, this cannot be done. Whatever is there is there.
So you lost the opportunity of filing an appeal.
We lost the opportunity of filing an appeal. Here, what my respectful submission is, subject to my lord's consideration, that the jurisdiction exercised by the RERA under section 18, directing for refund, was never the prayer of the petition of the complainant. The LOT had prayed for compensation.
No, first on the first point, after losing the right to appeal, which was created by the statute. Right.
Lordships.
Now you are preferring that on the ground of jurisdiction, whatever, of the RERA.
Absolutely.
So something that this can be entertained.
If my lord permits me, but I'll place one judgment of the apex court which says, by and large, I'll be relying on this. We had given the list of books. I'm on the proposition number C for the moment.
Mr.
My lordship,
Exactly the point.
exactly.
In spite of availability of alternative remedy,
My lordship.
right? Though it bears importance.
It is important.
Availability of alternative remedy.
I
Right?
can circumvent. that
No.
part.
It is available or it
Available.
was available.
Available.
Of alternative remedy of appeal was
Yes.
available for a period of 45 days,
60 days.
60 days, let us say 60 days. Now, if you read all these decisions,
My lord.
availability of alternative, adequate, efficacious, statutory remedy of appeal was available for period of 60 days by the statute. Because it is a matter of public policy.
Lordship.
Within that period, 60 days, that availability was there.
It is operative.
After 60 days, it was not available. It has significance.
Right. My lordships.
After expiry of appellate period, that option is not available
My lordship.
because it is a special enactment, special period of limitation,
Lordship.
and it is a matter of public policy.
Lordship.
We have been doing this wrong for
Lordship.
many years. This availability is with that meaning. Now, here is a case that availability is foreclosed by the expiry of the period of limitation.
Lordship. Correct. True.
Writ petition, writ remedy was available.
One way of taking it.
No, one way. That is the only way. Now I have understood. I did not understand also. I did not understand earlier also. All these decisions you go through, there are thousands of decisions, right from Than Singh Nakmol, Constitution bench, availability and non-availability. Availability, when there is a statute, right? Your right.
I got it, what Lordship has said. If
is
it's available,
subscribed
if it's
by
available,
a
then yes.
statute,
By statute.
not by CPC or CRPC.
Special statute.
Special enactment, special provisions, special period of limitation, and right is a creature of the statute. Appeal is a creature of the statute. That availability of alternative remedy was open for you for a period of 60 days to file before the appellate authority. After 60 days, that is not available.
Not available.
Writ petition can be entertained even despite availability of alternative remedy.
I got the point. But Lordship.
Have you got the point?
I got the point.
So don't just
So what I am on, my lord. I put the question to myself.
After
If
facing dismissal in a previous round of repetition.
that was on different score at all.
So, yes.
Score,
Now
different score.
tell me now, which principle of constructive res judicata is also applicable by explanation 4, section 11?
Yes. Yes,
Now,
yes, true.
Many decisions have
Yes,
come,
yes, true.
recent decisions have come. Please overcome that.
Only I put the question.
Otherwise, I'm not entertaining this.
Only on the point, I put the question to myself. If you think an order, a proceeding is ex faci within jurisdiction, does
First
it
you overcome this one. Why should I entertain?
if that appeal period is over?
That I know. I am clear about that.
That is only first.
I have said in the last one also, Article 142, Article 32, 226. I have already repeated. I am repeating now. All are gone.
Yes, gone.
Now, second option is when this could have been raised
Earlier.
and you did not raise.
Quite bona fide. It is
And
not raised.
lack of knowledge is no defense.
No, it's not a defense. Just bona fide not raised by anyone. That we understand. This was not
That is not the defense. Now tell me, how do you overcome all this?
If Lordship would permit the one liner, let's suppose I miss out on the limitation period of contempt and I come back with a writ petition, perhaps that would be maintained.
No, that is permitted. That has
But
been
that's
law
what I'm
laid
trying to
down.
say. If the law is, if the action is without jurisdiction ex faci, perhaps this needs an intervention.
No. First
Lordship
you,
would go into it.
first
Lay down the law.
First you overcome this.
Yes, correct.
Which you could have been raised in the earlier round.
As I approach the issue,
Show us.
I'll get to
Otherwise,
that.
I'm not convinced.
as I approach the issue,
I have understood lack of jurisdiction, complete
It's
lack
not
of jurisdiction,
I'm not
right?
arguing.
But it is when you approach it first time,
yes, yes.
right?
This
When
perfect
when in between all these things have happened, whether you can raise this issue.
Next Monday, I'll not be in town. That's what.
I'm ready to learn.
Yes, no.
I am ready to learn from
I'm only
Mr.
addressing
Boningo
that
issue.
point.
But at least whatever little knowledge I have put it
I'll
across
try
to you.
I'll try to satisfy you, my lord, on that.
You have many obstacles to overcome. To us.
And I'll be relying on New Tech, which the other case, New Tech.
New Tech is also there.
New Tech
On the basis of
explains
New Tech, it has been dismissed.
No, New Tech explains the jurisdiction distinct and different of the authority, the RERA, and the adjudicating officer authority. So there's no interlapping, definite and distinct compartments. I was on that.
I am on the availability
Yes,
and non-availability.
yes. The first hurdle I have to come.
Yes, Bonik, senior counsel. I have sought listing of the case. I'm paying for a petition. I have
Next
sought
Monday.
listing of the case on next Monday. Raise the case accordingly.
Okay, so much.
Who is for the petition? Other side? Revenue? Anybody? A for the side, revenue, 1. M. Bormon, Junior Government Advocate, Assam, for the phone number? 4. Okay. We'll come back.
Daily list, item 21.
Wait. The speaking order. Page 11, annexure 50.
1.
Okay. May I read it, my lord? Whereas the Honorable Gauhati High Court in judgment to provide an opportunity of hearing to the petitioner such as Deputy Commissioner authorized the Co-District Commissioner dated to conduct an individual hearing of the petition. Accordingly, the Co-Commissioner submitted his report. The government land has been reserved for TB hospital and the applicant H is unauthorized occupant of the said land, has submitted an application for settlement. Whereas an inquiry conducted by the Co-District Commissioner Gauhati conclude the settlement petition of the petitioner is not admissible under the land policy and rules thereof. However, as the case has already been placed before and approved by the HDLAC, my case was placed and it was approved by the Subdivisional Land Advisory Committee. In its meeting held on 11/12/2020, the settlement petition was forwarded to the Revenue and Disaster Management Department, Government of Assam, for necessary instruction. Further action in accordance with law. Accordingly, the Government of Assam, by letter dated, instructed the undersigned the settlement proposal shall be placed before the HDLAC for cancellation. Whereas the said settlement proposal was approved by the HDLAC and had not been approved by the such and such in its meeting held on such and such, examining the matter and came to the following conclusion. The government land for which the petitioner has sought settlement had already been reserved for the TB hospital. The settlement petition of such and such erroneously forwarded to the Revenue and Management Department, overlooking the fact of point number 1. During the hearing conducted by such and such, where the petitioner was asked to vacate the land, he could not produce any substantive document. He had been residing or occupying the plot prior to such and such, which is mandatory condition for getting settlement. In the light of finding such and such, is hereby cancelled. So my approval was cancelled. This I have approached the court because of the last judicial order passed by this court. I have all my documents since 1981. I am over there. I approached this court for settlement. Court, in pursuance to the land policy, said that they are entitled to settlement.
Court,
This order.
which part?
Entitled to, subject to, that is the first order. That is that page your lordship will find. Not for settlement, but it was said that they can ask for a settlement. That was first order at page 30.
Page?
30. It starts at page 29, sorry, my lord. Your lordship will first turn to page 29. My lord, your lordship will find serial number 5 is the petitioner herein now.
Yes.
And my lord, I will proceed further. Serial number 11 and 19. My lord, on the same DAG number, in the same place, they have been given settlement and patta. And they have been said that plot of land is not within that territory of the TB hospitals. And ultimately, in this petition, the direction was, my lord, page 31. In view of the aforesaid, the writ petition is disposed of with the direction, Deputy Commissioner, to consider the application of such and such 2010 filed by the petitioner to the writ petition for allotment settlement of the land under this their position. While considering such application, the Deputy Commissioner shall also bear in mind the land policy of the state for Assam formulated in the 18th and the requirement of the provision of 1886 regulation. The sixth exercise is directed to be completed in 6 months from the date of receipt of the certified copy of the order today, along with the copy of the writ petition annexed appended there to the filing with the Deputy Commissioner, 7 days such and such. Till the decision taking order passed, the petitioner shall not evict from the land.
For consideration.
Consideration. Thereafter, my lord.
As per the land policy.
Land policy. And page 33, another writ petition was filed when, my lord, notices were given. Section 18 notice, rule 18 notice was provided.
Page?
Page, it starts at page 33.
Yes.
My lord, page 36, your lordship will find in para 2, the 18 notices were said, and para 4 in page 36. It is noticed that in order to invoke the provision of rule 18.2, the condition precedent is that no bona fide claim of any right may be involved in respect of the person who has entered into possession of the aforesaid classes of land. So, my lord, with all humility, I will place this bona fide claim. I will place in my representation what is there. I will place it before your lordship. In the instant case, the claim has been made by the petitioner that they have all submitted application for settlement of the respective plot of land as per the legal right described format before the concerned authority in the office of Deputy Commissioner, Kamrup Metro. In this writ petition, the petitioner has jointly agreed by various notice dated issued by the circle officer. A reading of the notice such and such that has been claimed. A reading of the rule would show that such person who had entered into possession of government caste land or wasteland or estate over no person has acquired the right of proprietor, landholder, settlement or any land that had previously been reserved for roads or roadside land or for grazing a village cattle or other public purpose or entered into possession of the land for which he is excluded by the general or special order. When further no bona fide claim of right has been inferred, he may be ejected from the land, vacate the land forthwith. It is noticed that the order to invoke the such as the condition precedent, no bona fide claim of right may be involved in respect of the person who has interposition the aforesaid classes of claim. In the instant claims has been made, but they have all submitted application for settlement of the respective plotted land as per the legal rights. And then, my lord, acquired under they have acquired under clause 14.3 of the land policy of Assam 1989. Accordingly, it is contention that may be making such application where a legal right has been provided of the land policy. The petitioner makes a bona fide claim of right in respect of the land under their occupation. And then, my lord, para 7 onwards, ultimately the court held that, my lord, this bona fide right, one aspect of the matter, my lord, if I can, with your lordship's permission, my lord, I can just play. If this land policy, I will come next to, my lord. It was not placed. The law was that, my lord, regulation was framed in 1886. The settlement rules after the amendment came in 1931. My lord, the regulation, if I look into, my lord, section 6, but regulation 6, my lord, if your lordship's, my lord, permission, my lord, if I can take your lordship. Limitation technical law. My lord, may I read it? Rights which may be acquired over land. No right of any description shall be deemed to have been or shall be acquired by any person over any land to which the chapter applies, except the following: right of proprietor, landholder, and settlement holder, other than landholders, as defined in this regulation, and other rights acquired in manner provided by this regulation. Right legally deprived from any other mentioned in clause A. C. Right acquired under section 26 and 27 of the Indian Limitation Act, now Act 9 of 1908. This is what I want to claim, my lord, before. My lord, this itself is a bona fide right. And I have placed with my representation before the deputy.
This right, see, whether you can claim by writ petition first.
No, my lord. I cannot claim by writ petition. I am not asking this. When I have placed this fact before the factual aspect before the authority.
This C is by writ petition or not?
No,
Or by that authority or not?
well, the authority has overlooked those aspects. That is why I am before lordship. And I will place other documents. Well,
This right you have to claim, perhaps with my little knowledge, by way of
civil suit.
civil suit
I can-
and from your side.
Well, I can claim nowadays, again, my lord, subject to immigration, my lord, I can file a suit in a play claiming right through adverse possession. Previously, it was a defense. Now it can
Against
be,
the state, against the government,
my lord,
if you claim under right clause C, it has not by writ petition, at least to my little knowledge.
why I am
So question of consideration under clause C in this writ petition is out of question.
No, I'm not asking that. What I am to place before you, see, when I have placed this factual aspect before the authority, which by way of a writ petition directed the authority to look into.
The question is first, whether it is two things. One is rule 18.2.
18.
Firstly, it comes into consideration for other public purposes.
Madam,
Rule 18.2, page 37.
madam,
The case of the respondent perhaps is that it is reserved.
No.
This land was reserved for TB hospital.
Here, my lord, all right, my lord, your lordship.
And to my understanding, that would come under other public purposes.
My lord, I admit.
Question is when it was reserved.
My lord, that is the question. I will place before your lordship the documents. When in the circle officer, your lordship, just for a moment, my lord, your lordship will look into, my lord, page 41. This document, page 41 below of 2021, copy of information such a resident of such and such. Inviting reference to the letter of subject cited above, I am directed to clarify the following points. In the remark column of cheated copy, there has been mention of TB hospital. Further, you are requested to furnish following information document for taking necessary action from the photograph duly signed sealed circle officer. This was Joint Secretary to the Deputy Commission. In 21, then, my lord, at page 43, your lordship will find. Same DAG number. Same DAG number regarding settlement, and it was said, they have said it is not allotted to TB hospital. Page 43. These factual aspects were placed before the Deputy Commission. He has overlooked all these things. Page 43. Favor of Arun Singh, son of Ramananda Singh. And same DAG number, village Ulubari, same place. My neighbors. This is one of the document. Then, my lord, page 45.
You are Arun Singh.
My lord,
You are not Arun Singh.
I'm not Arun Singh. I'm saying, my lord, same place.
Where is your finding regarding your land?
My this finding has not been given. My representation, that is starts at page 100. From para 5 onwards, I
Is
have.
there any report of this similar kind is available in your case?
My lord, because I have placed.
Because you have shown us some petitioner number.
My lord,
Some petitioner number, those two are Sail Devi and Arun Kumar Singh.
my lord, I'm giving those numbers are
Serial number 11 and 19.
19.
Those are in respect of those two persons.
Persons.
Settlement is made.
Made.
There is a clear report.
And
Where is your clear report?
my that report was, I have asked them, give me that report. They don't provide. That is, my document is there at page. Your lordship will find that page.
Now, have you enclosed the SITA?
My lord,
Have you enclosed the SITA?
that is not there, my lord. But only thing, my lord, your lordship will find at
No,
page 40.
Slight distinction in facts makes a whole lot of difference.
My lord,
So far as Sail Devi and Arun Kumar Singh,
same DAG number.
though you were petitioners in one petition, but there are different reports in respect of those two persons.
But my report is not given. Page 40.
That does not mean that you were similarly situated.
My lord, but they are, my lord, neighbors. My lord,
Maybe,
my lord.
maybe.
Because maybe till the Ganesh Mandir there is there. After that, may not be there. But
Just
my lord,
because adjacent does not mean that all are similarly situated.
but one thing.
One may have a 10-story building in the adjacent plot. One may have a test house in the other plot.
Another issue that I came into my mind, when it is sent to the disaster management, whether the DC unilaterally can cancel it. DC has cancelled because he is the chairman of the subdivisional advisory committee.
That is a different issue, but it has not crystallized into any right. SGLAC is, this court has already held in other matter regarding SGLAC approval is not the, does not result in crystallization of a right.
Anyway,
Ultimately, the settlement is to be made, approved by the
revenue and disaster management.
state government. Right. But since it had not reached any finality regarding your the earlier direction was for consideration.
Consideration.
And consideration is not a positive direction.
Not positive.
Consideration and examine your settlement application with regard to the land policy 1989.
My lord, another issue, my lord. My lord, 1983, there was a division bench where looking into 83 and 88, while looking into this 18.2, they have discussed the bona fide right of the person staying over there for a longer period has to be considered by the authority.
Land policy also says an encroacher is an encroacher.
My lord,
same land policy, 1989.
well, I'm not.
Long occupation does not.
I am not on the policy.
Transform an encroacher into a bona fide.
My lord, I am not on the policy. I am on the, my lord, regulation and the rules. 18.2. 18.2, while discussing 18.
Before regulation 5 comes regulation 6, perhaps regulation comes regulation because proprietor or landholder, these are not.
I am not.
It is only settlement holder.
No, my lord.
Right.
My aspect is this, my lord, whether the authority can himself cancel that, my lord, the approval. It was for the revenue and disaster authority, the state to cancel it. They cannot send it back to the DC to cancel it. my lord.
Okay, that can be examined, but your, at the same time, your right has not been crystallized.
My lord, only thing, my lord, if you
Because ultimately the finality is to be given by the state government in the review.
my lord, in the disaster. My lord, another aspect, my lord, when these matters were placed before the authority, in my representation, my lord, it starts at page.
Yes, similar issues came up earlier.
Similar issues, my lord.
Same kind of order.
Yes, speaking orders were issued.
What is the order passed by this court?
Because lordship will kindly see, my lord, page 51. Prior, my lord, this is the genesis. Page 51, there was a batch of writ petitions.
Yes.
Where, my lord, they have challenged all these writ petitioners claim to be in occupation of tag number 97.
From para 50.
Yes, my lord, paragraph 50.
Para 50.
Yes,
Yes.
lordship will find it there, my lord. Page 98.
No, Mr. Barpujari,
Yes,
these kind of speaking orders
yes, my lord.
were part of some other repetitions also.
Other writ petitions pursuant to these orders, the authorities took up the exercise. The persons were hurt. They were not hurt because they came belatedly. 26 numbers of writ petitioners were hurt arising out of this order, page 51 order. They were hurt and the speaking orders were issued. Those speaking orders were put to challenge before this honorable court, just identically as the present writ petition. There we had filed the affidavits, individual affidavits were filed, and upon consideration of those affidavits, my lord, this honorable court was pleased to dismiss that entire batch of writ petition. Now they went in appeal. In appeal, my lord, the honorable division bench was pleased to hold, my lord, that they are not entitled for any settlement over the part and parcel of the land in question, same land, part and parcel of land, which is otherwise reserved for TB hospital. Now it is known as, my lord, Pragjotispur Medical College. This is the second medical college. More so because of the fact that, my lord, the old GMC building is under a process of, my lord, overhauling process, my lord, reconstructions, and there is a serious, my lord, and severe patient pressure in the new hospital. So these plots of land will be required for, my lord, accommodating, my lord, the patients and, my lord, setting up of new, my lord, operation theaters and all these things. To that extent, the honorable division bench was pleased to again direct the authorities to take a further call. If at all they are, my lord, entitled for any settlement, not in that plot of land, in any other land. We, the state, had filed a review against that order, my lord, of the honorable division bench, and in a review, my lord, honorable division bench was pleased to, my lord, allow the review petition, thereby directing, my lord, to holding that the writ petitioners do not have any semblance of right whatsoever, my lord, for settlement under the land policy. And they were asked to, my lord, immediately vacate, and accordingly they have vacated, and, my lord, their properties have been demolished. This is a very recent development. Now, so far this writ petition is concerned, we may be required to file an affidavit on facts. That is one, my lord. And so far these documents are concerned, my lord, that the earlier two persons were settled. We have taken a specific stand in our affidavit in those earlier writ petitions that this was erroneously done. It was erroneously done. And taking cognizance of those factual aspects of the matter, my lord, this honorable court is pleased to dismiss the writ petition. At the end of the day.
Those sale levy and all.
Yes, at the end of the day, my lord, this part and parcel of lands is within the circumference of the Pragjotispur Medical College, and there is a severe, my lord, patient pressure. So under that, my lord, situation, it cannot be done. And there is another aspect of the matter. Kindly see, my lord, if lordship may be pleased to come to page number 115 for a moment, my lord. I am troubling, my lord. For a moment, my lord, page 115. And the, my lord, the translated part is available at page 114. Page 114.
114, Annex 8, 14.
one for here to, in the copy served to me, my lord, it is a, my lord, khazana receipt, purported land revenue receipt.
It is not there.
That a page.
My lord, I don't know, my lord, there may be mismatch with my pages. Here I find it to be.
127.
127. I'm so sorry, my lord. Page 127. 127.
Yes.
127. This is a purported land revenue receipt. Now, admittedly, they are in occupation of, my lord, government duct. How can a person, my lord, pay land revenue? And, my lord, in that earlier batch of writ petitions, my lord, where the authorities have taken a fact-finding exercise, this speaking order was passed in individual capacity. In those writ petitions also, my lord, individual speaking orders were passed. In the affidavits which we have filed, separate affidavits, my lord, there we have annexed all the statements made on oath, my lord, before the district authorities. There we found, my lord, that they have produced, my lord, fraudulent documents, manufactured documents. And those aspects of the matters were also taken into consideration by the coordinate bench of this honorable court. And hence, my lord, those writ petitions came to be dismissed. This is how the matter stands.
Issue notice at this stage.
Absolutely, my lord.
Only thing, my lord, because they will evict me, my lord, because the last order is there.
You have not, but even sale levy is ousted.
But they say they will file affidavit, but till for a day, because if I.
No, that gets prolonged.
But
If anything, any notice for eviction is passed.
because my last order, you also will find the division, the judicial order is there.
The reviews, let us see the review order.
Review order is not available with me right now, my lord.
We'll take up tomorrow all this, then we'll decide the writ petition then itself.
Is that, my lord, paying.
We'll decide the writ petition
Yes,
itself,
yes.
the motions.
Absolutely. But I will come up with the order passed by the writ court, my lord. Then the order passed by the writ appellate
Page
court and the
99 you have
order
to do.
passed in review. These three orders I will place before this honorable court tomorrow. Yes,
Tomorrow, then.
definitely.
Since you are asking for an interim prayer,
Only because, my
let
lord,
let us, purposely have the opportunity.
My lord,
We'll consider the
He's a good friend
interim
of
prayer, otherwise we are inclined to issue notice. Thereafter, we'll exercise our power discussion whether to grant interim prayer or refuse interim prayer.
Absolutely.
Otherwise, I am inclined to issue notice. In the face of all this, which I have heard, that individual writ petitions were dismissed, writ appeals were, writ appeal order was passed with certain condition. Thereafter, review was allowed. In the face of those, whether I should pass an interim order or
My
not.
lord, that is.
Otherwise, I will issue notice returnable for 4 weeks.
But page 99.
And that opportunity will be available if any direction for vacating
There is a
the.
direction, my lord, page 99. Page 99, there is a direction.
No, after the interim order.
No, my lord, that order itself says. The court further directs, page 99. Or directs, upon speaking order being deputy commissioner shall notify the notice board about the fact of speaking order had been passed for a period of 30 days from the date no coercive mandatory petition agreed. So 30 days from the date, madam.
That 30 days period with all respect was given as a
30
leeway
days, page
to the
50,
petitioners
12/6/26.
for assailing the speaking
Let us
orders.
see tomorrow.
12/6.
P.K. Roy is senior counsel for the petitioner. And Mr. R. Prohibitions, land spending counsel revenue, S.R. Borua, land engineer and advocate for the state of Congress. As sought for by Mr. Prohibitions is the case tomorrow, day after tomorrow.
Day after tomorrow.
Day after tomorrow is, my lord, 15, my lord, 15 I will be out of station. 15.
16 tomorrow or 16.
My lord, my lord, because 30 days will be over, yesterday it was over.
Prohibitions will ensure that
But
till Thursday, nothing will be.
My lord, that observation, my lord, I have not said that. My lord, they will not evict me because, my lord, tomorrow they come.
I'll prepone the listing. If something is happening. Thursday.
Because,
They
my lord,
will have the first
experience has gone that way, my lord. Morning we mentioned by
Okay, then let us to have tomorrow.
Tomorrow, my lord, tomorrow.
If
Yes.
you're so insisting, let us have tomorrow.
Yes, but
We'll decide.
Your lordship may decide.
I'm so deeply.
14. Item 22.
May I please?
Yes.
My lord, petitioners are
residing in a river island, my lord,
Hmm.
for long decades. And their land has been acquired, my lord, for construction of national highway, my lord. And now government stating that as the lands are fall in the government land, they have not fully paid the amount, my lord, regarding silentium and land compensation.
You're okay. Okay. Oh, yes. Land acquired.
Land acquired, my lord.
Huh.
And land acquired, my lord, by giving notice indicating that as we have received the amount, therefore vacating the land within 15 days.
Within?
Within 15 days. After acquiring the land, said notice was served, my lord. And
It is under what law land has been acquired?
land has been acquired, my lord, as we are residing in a government land, my lord.
Oh, you are government land.
But as per their observation, my lord, we have living in the land for long decades, my lord.
Long decade is different thing. You are all settlement holders.
No,
You are
my
the
lord.
patta holders.
No, my lord. No,
No.
patta was land.
So
for-
government land.
Government-
Admittedly government land.
entirely
Yes.
government.
What
land.
kind of compensation you have received?
We have received, my lord, land surface compensation only, my lord. So
What
100%.
more? What more is
100% lithium was not given, my lord. But as
100%?
lithium,
Solution not given.
not given, my lord. But they have made the land acquisition estimate, my lord. As per column number 19 of the said estimate, my lord, we are entitled for more, my lord.
So you are agreed by non-receipt of 100% solution.
And my lord, regarding the re-evaluation and rehabilitation and resettlement, my lord. That was,
Re-evaluation? What kind of re-evaluation?
my lord, as per the right of fair compensation and transparency act, my lord, there is a provision for rehabilitation and resettlement, my lord. That was also not done, my lord. My pair, lordship may kindly permit my pair portion, my lord. That pays
Your
150.
second prayer is land compensation. Whether you are entitled for land compensation.
My lord, as
Surface compensation, I can understand.
my lord,
Zirat.
Jira.
But whether you are entitled for land compensation,
Land compensation, my
we
lord.
can examine solution part. Right.
Land commission, as my lord, we have residing in the land for long decades
No,
and
tell
have
me
prayed
under what provision?
and prayed before the
Under the
government.
2013 Act or National Highway Act or Land Acquisition Act 1894 or 1964 Act. Which act?
2013 Act, and my lord, they have also introduced the gazette notification of direct purchase formula, my lord.
Okay.
As per that notification, our payment was made, my lord. A small portion was given, my lord, not the whole.
Where is it?
payment.
Where is it? Amount assessed.
Amount we have assessed, we have by making an estimate chart.
And these notices are of 2024.
Page 110, my lord.
Page
110, my lord. 110 onwards, my lord, for all the petitioners, my lord. We have indicating total amount as per estimate, my lord, but they have paid and the balance we have received by indicating our respective award numbers.
So basically page 110, the balance amount you have not received.
Not received.
That is your grievance.
My lord. Yes, my lord.
Well, at this stage, Lordship, I'm appearing for response number 4 and 5.
4 and 5.
Lordship, I have to take instruction. Otherwise, Malad, they are occupying government land and 100% solution. A decision has been taken. That decision has been challenged by them. They have challenged the decision at annexure 1, page 163. So this is
163.
yes, Malad.
What is the decision?
That 100% solatium will not be given.
Okay, they want 100% solution.
Yes,
That can be examined.
yes.
That can be examined. You're entitled, you will receive that.
But they have
Otherwise,
calculated.
your land has been acquired. Where you, the land, government lands which you were occupying have been acquired.
But
Now
in the-
it is entitlement.
But in the whole Majuli district, my lord, all the lands were government land, my lord. We have
Whatever.
stayed
That we
for
cannot-
past long years.
We cannot convert government land to periodic patta land.
But our demands has not been
Regarding non received at page 110, we'll examine that. And regarding the decision whether you are entitled for 100% solatium or not, we can examine. We'll examine that solatium part.
And my lord, there were complaints regarding anomalies also, my lord. Some person has given Miyadi Patta to other persons and taking the conventional land compensation, my
No,
lord.
there
We
is
have
no,
also-
no negative equality. Claim positive equality. Negative equality is not to be praised. But Mr.
আমি already
D. Bora,
decision তো আছে
Learned Counsel for the petitioner.
ডিসিডি কানে আপনি পে করে দিও
If you are entitled for solatium, definitely you will get it. Which for 1 to 3? Okay, Mr. Andas.
1678.
নোটিশ
Learned Junior Government Advocate, Assam. So the respond number 1,
678.
6, 7, and 8.
9 to করে দিও
9.
9 to করে
aforesaid, Standing Council Revenue Department for the respond number 2 and 3. And Mr. Dean asked.
I am appearing for 4 and 5.
Public Works Department for the respond number 4 and 5.
Five.
All respondents are covered.
Lodge covered.
The petitioners. In this, by this petition, command, the petitions have entirely sought for 100% solatium benefit. As per the direct purchase, under the direct purchase scheme. Post office. The petitioners have stated that though the respondent authorities have determined, have estimated the amounts of compensation payable to each of the petitioners. But till date, only a part of the said assessed compensation amounts have been disbursed to the petitioners. Close stop. Para Mr. Bora, Learned Counsel for the petitioner, has referred to the table mentioned in paragraph 9 of the petition to substantiate his contention. Full stop. No matter would require consideration, issue notice returnable on so and so, as Mr. So and so has appeared, accepted notice on behalf of so and so. No formal notice, extra copy you need to. The respondents will ensure that their respective counter affidavits are filed before the return.
1408, 14th August. Item 23.
With please, your lordship. Dimahasao district. It is slightly connected to that other 3000 bighas matter, lordship. Here the petitioners are from 5 villages, lordship. From Kruming Langso, Nobodi Longkukro, Choto Larpeng, Langfly Disa, and Hanjang Langso. And then the matter pertains to 2 plots, 2 projects which are interconnected or due to the integrated cement plant production, lordship. So now for the cement plant site, they have taken the lands of Krungming Langso and Nobodi Longkukro village, lordship. And then connected to it, there is a mining lease also. For that area, Choto Larpeng, Langklai Disa and Hanjang Langso villages, lands from these three villages have been leased out by the Dimasa Council to the AMDC Lordship. And with regard to the cement plant, it has been allotted to respondent number 12, that is Mahabal Cement Private Limited. So now, Lordship, the thing is that this is an integrated plant. And so even though the other matter is going on, Lordship, it is still pending. But then the scope here is larger, Lordship. Because earlier we did not have the allotment letter, we did not have the patas also. So we have challenged those documents here, Lordship. And then there are other villagers also who are
the petitioners?
petitioners are Dimasa villages, Dimasa and Karbi villagers, Lordship. They pay whole tax, Lordship. It is also called house tax, that is paid in lieu of land revenue, Lordship.
You pay house tax.
Yes, Lordship. Under the ALRR, it is in lieu of land revenue, Lordship.
Hmm?
It is in lieu of land revenue. Under Regulation 47, the definition is there in the ALRR. Under Regulation 47 and executive instructions.
What you are challenging?
Lordship, the allotment of the land to respondent number 12, that is Mahabal, and the lease of the land to AMDC, Lordship, with regard to the mining.
Those are lands where in respect of which you are paying house tax.
Yes, Lordship.
It is your case.
Yes, Lordship. We are traditional landowners, Lordship. This is a 6th schedule area, so all the regulations of the ALRR will not be applicable there.
Yes. In similar matter regarding the allotment of land to the private cement company, a similar case has been filed by my learned friend, which is being numbered as 467 of 2025. And that has been listed on 37, next date of listing is 37/2026. May I pray that let this matter be taken along with that. 15/7. 37. 37. But all but these respondents are at least AMDC is also there in that petition also. Respondent number 12, 13. Yes, 12 these are private parties. They are being implemented in that writ petition also.
12 is there.
12 is there.
13 is not.
13, if 13 is new, it has to be served. We should
Yes, yes.
at this stage.
Yes, yes,
Thereafter we'll thereafter we'll take all the matters.
Lordship.
Okay. Third, Mr. A.I. Kathar. We are counsel for the petitioner. Who is for Union of India? Mr. J.K. Goswami. Learned Central Government Council. For the respondent number 1. 8. Mention Minerals.
I am appearing for 2, 11 and 2, 14.
T. Nath, Learned Senior Government Advocate. For the respondent number 2.
11 and 14.
11. And 14.
One.
And Mr. R.M. Das. Learned Standing Council. Dima Hassa Autonomous Council. DHAC. For the respondent number 2, 4, 5, 6. And 7. 7. The PCBA is not here. PCB is Siddhartha S. Boga. S. Boga, Lordship, he is the appearance. The petitions are residents of 5 villages. That's paragraph number 1. which are located in Umrangso area. South District. So the petitioners are aggrieved by allotment, stroke leasing of lands in favor of leasing of lands by the respondent authorities in favor of the respondent number 10, 12, and 13. Parallel then counsel for the respondents have submitted. And counsel preparing for the state respondents have submitted another repetition. WBC number
467
467
2025.
2025. Involving similar issues, is pending before this court. As the matter will require consideration, let notice be issued. The notice is made returnable on after 4 weeks. Give it
17-8.
as Mr. Goswami has appeared accepted notice on behalf of Mr. Nath has appeared accepted notice on behalf of and Mr. Das has appeared and accepted notice on behalf of no formal notice needs to be issued to the state respondents. Extra copies, also put a petition. The petition shall serve a copy of the writ petition along with annexer to Mr. S. Borua, Standing Council, Assam Pollution Control Board, within 2 working days from today for service of notice upon the respondent number 9. So the petition shall take stage for service of notice upon the respondent number 10, 12, and 13 by speed post within 2 working days from today. It was promised to Korea.
24.
Yes.
I have purchased a plot of land measuring 4 acres, Your Lordship, where registered sale deed being number, Your Lordship, 185 to 1985, Your Lordship. So therefore, Your Lordship, pursuant on the strength of the sale deed, Your Lordship, my name got mutated on the aforesaid plot of land on 25/5/1991, Your Lordship. So thereafter, Your Lordship, what happened is that respondent number 6, Your Lordship.
Respondent number 6.
Respondent number 6, Your Lordship. So right from the very inception, it was pursuing the said plot of land, Your Lordship. I have been in continuous possession of the plot of land. But the respondent number 6, Your Lordship, we have challenged it on by Mitch appeal number 52/2013 and 14. Your Lordship, after
Cancel the mutation.
yes, Your Lordship, after 12.
Shortage name recording with serious or name this is an application of some Board of Revenue.
Yes, Your Lordship.
Your appeal was allowed.
Uh,
The sailing order which was set
Then-
aside.
Annexer,
Demanded back by a matter before the review for disposing of the case affairs after hearing both parties. So sought for report from the so and so. The recent decision was case to pass an order. Concerned officer to proceed with indication and remove the petition reported his name is Sita and other document. But there was two, so there were 2 standing orders issued first by the so and so. Some title suit is pending.
Yes.
one title suit is pending, Your Lordship, because of that particular fact, Your Lordship, the circle officer is not complying with the order of the 2 standing orders, Your Lordship.
Yes, Mr. Das.
Well, rightly or wrongly, there's a title suit pending. Outcome of the title suit will decide everything. More or my lord. No.
Whether cycle officer
If a lordship come to pay
can
spend,
disobey the order of the Board of Revenue.
Yes.
maybe some title suit is pending.
Page
It
23.
is with regard to mutation.
Yes, yes, my lord.
Title suit is pending for what purpose?
It's for declare right title interest plaintiff over the suit land, my lord. His
Who
tit-
is the plaintiff?
Plaintiff is some other person, my lord. Rightly or wrongly, his title has been clouded, my lord. His title has been
No, no.
clouded.
It is a question of, firstly, for the circle officer, it
With-
is question of obeying a direction by the Assam Board of Revenue. Firstly. Secondly, whether any injunction order is there.
No injunction, Your Lordship.
But my submission, my lord, but his right title interest is clouded.
No, merely by filing a civil suit under section 9, anything can be filed. Section 9 of the CPC says what? There is any restriction, anything can be filed just because filing of a title suit, whether it is clouded.
No, no, like with regard.
It would be adjudicated.
Yes, my lord. Moreover, my lord.
And it is not clouded. Mr. Das, you can go and file as a plaintiff against this petitioner also. There is no bar. Whether it will be dismissed under Order 7, Rule 11, it is a different matter.
Well, I'll get to it, sir.
Sir, Lordship, they cannot confuse the two different
Hard, Mr.
jurisdiction, Your Lordship.
A. Dewan, counsel for the petitioner, will issue notice at this.
Yes, yes.
Let him come. Respond number 6 also.
Yes.
Mr. N. Das, Ms. N. Bodoloi, Revenue 1,
1 and 2.
2,
3,
Mr.
4,
N.
5.
Das,
3, 4, 5.
3, 4, 5. So the petitioner has approached this court on the premise that the respondent number 5 has not carried out a direction given by the Assam Board of Revenue in its order dated 7/7/2022, passed in case number 18 RA within bracket HO stroke 2020, and also an order dated 5/4/2025 passed by the respondent number 4 in case number HJRK within bracket Miss 52/2024 on the on purportedly untenable premise that a title suit, title suit number 68/2025 is pending before the Court of Learned Civil Judge, Junior Division, Hojai. Issue notice returnable on so and so. As so and so appeared accepted no formal notice, extra copy, 2 working days, petitioner shall take state for service of notice after respond number 6 by speak for within 2 working.
17th August, 1708.
Extra copies.
Daily list, item 25.
May I please? My lord, please. This petition, my lord, petitioner before my lord, your lordship are the, my lord, members of the Gau Panchayat, 7 members of the Gau Panchayat, my lord. The grievance of the petitioner is that, my lord, the Gau Panchayat president and the secretary, my lord, under the Act, my lord, section 17, which requires the whole meeting bi-monthly, my lord, once in 2 months, my lord. My lord, since last 16 months, they have not convened any meetings out of the Gau Panchayat. And they have forged the, my lord, signatures of the Gau Shobha. For holding Gau Shobha, they have hold some forged signature, taking the help of that. They have, my lord, misappropriated the Panchayat fund, my lord. Under section 112 and 121 of the Assam Panchayat Act, my lord, state government has the authority to, my lord, supervise and inquire, my lord. So kindly see 112 and, my lord, 121.
112.
112. and section 121. Yes. Then, my lord, we have filed representation page, several numbers of representation, more particularly before the Commissioner and Secretary, Panchayat and Rural Development Department, annexure 15, page 77, we have filed, agitating the details allegations, my lord. We have also annexed the document to show that how they have withdrawn the money, my lord. At this stage, my lord, I pray for, my lord, issuing notice upon all the respondent, and my lord, the block development officer shall ensure release of any amount to the Gaon Panchayat, subject to, my lord, verification and all that. Let them respond. Yes. Heard Mr. J.M. Chaudhary, Learned Counsel for the petitioners. Miss N. Bora. N. Bora,
And burden, yes, Lord.
Standing Counsel, Panchayat and Rural Development Department for the response number 1, 2.
1, 2,
4,
and 4.
and 6.
Lordship 6 is your by name, so I can't have
4. Mr. N. Das, Learned Counsel Advocate for the response number 3. First of the petitioners, comma 70 number, comma R. Ward members of Porit Puna, Osimganj, Gaon Panchayat. The petitioners have instituted the instant writ petition, stating that they have a common cause of action to espouse. In this writ petition, the petitioners have stated that the respondent number, my lord, respondent number 6, 6 and 5, 5 and 6, and the respondent of 6, who are the president and the secretary, respectively of Poritmuna or Simganj Gaon Panchayat, have not adhered to the provisions of the Assam Panchayat Act 1994 as amended while conducting the affairs of the Gaon Panchayat, comma, more particularly, comma, section 17 thereof. Full stop. The respondent of the said two respondents have not convened bi-monthly meeting of the Gaon Panchayat for the last 16 months. Yes. Have not convened any bi-monthly meeting of the Gaon Panchayat, as required by section 17, comma, in the last 16 months. Full stop. The petitions have alleged that a number of irregularities have been committed by the said two respondents, which include misappropriation of Panchayat funds. Full stop. The petitioners have stated that as the representation submitted before the empowered authorities have not been given due consideration, the petitioners are compelled or constrained to approach this court by the instant writ petition, seeking a direction to the respondent authorities for exercise of powers under section 112 and section 121 of the Assam Panchayat Act as amended, and to conduct an independent, impartial, and time-bound administrative, financial, and technical audit into the affairs of the Gaon Panchayat.
concerning alleged siphoning and misappropriation of Panchayat Fund under the 15th Finance Commission, MG and Rega and PMAY-Z schemes. Which notice be issued, notice has been returnable on so and so. As Ms. Bora has appeared, accepted notice on behalf of so and Mr. Das. Government advocate, Union Government Advocate has appeared and accepted notice on behalf of so and so. No formal notice is required to be issued to the state respondents. Concerning transport applications shall furnish requisite number of extra copies of the requisition along with annexa to Mr. Ms. So and Mr. So and so. Within 2 working days from today, the petition shall take step for service of notice and the respond number 5 and the respond number 6 by speed post within 2 working days from today.
In the meantime, my lord, respondent may ensure only that part, my lord.
Let them respond.
Not to release money without, my lord.
Let them respond.
17th August, 1708. Item 26.
My senior is going to family court, Lordship. Please
Hmm?
allow. If my seniors go to family court, Lordship.
Family court is more important than high court, it seems.
Item 27.
Family court.
May I please, Lordship? Lordship, CIC don't have a standing counsel in Assam, so notice would not have been. I will serve the notice of the admission. My lord, this issue is pertaining to a short issue, my lord. I am praying for early hearing of my second appeal, my lord. It is pertaining to my compassionate appointment. I am seeking some documents from the institution, Punjab National Bank. My lord, I have filed a request.
This Central Information Commission,
Yes, my lord.
you are a lawyer or
I am a petitioner, I am not a lawyer. my lord.
then address on the jurisdictional issue? Territorial jurisdictional issue.
There is. My lord, but Karnataka High Courts and other High Courts have issued.
You address. First you address.
I have addressed the CIC, my lord. I have filed a application before them for early hearing.
Who is the PIO? SPIO?
The PIO for CIC, my lord.
Who is the SPIO?
The Punjab National Bank, my lord.
Who is that? Who is that authority? SPIO?
My lord, it will be the CPIO.
Or CPIO? Yes. Who is the
CPIO New Delhi.
CPIO? Who is the CPIO?
CPIO would be, my lord, Punjab National Bank head office New Delhi. My lord.
New Delhi.
Yes,
CPIO.
Yes, ma'am.
And who is the first appellate authority?
That is also from head office New Delhi, ma'am.
And the CIC, second appellate authority, is also Delhi.
Delhi.
So then, why you are referring to Karnataka High Court? There is nothing about CPIO. Where is the mention of CPIO here? Annexure H. Where is Annexure H?
Page number 59, my lord.
Where is your application? Under
Application
section
at,
6.
Application is at page number 40 and 41, my lord.
40.
40 and 41.
This is to Chief Information Commission. Where is the application of CPIO?
This is pertaining to second appeal, my lord. Second appeal in CIT.
Okay, address as if I don't know the law. Address the court as if I don't know the law. Where is your application under Section 6 of the Right to Information Act? Where is your application?
Application for
Under Section 6 of the Right to Information Act to the CPIO.
my lord. My lord, that would be on. Oh, my lord, page number 59, my lord.
This is not the application.
No, it
Your
is the,
application under Section 6 of the RTI Act.
this is the reply of that. My lord.
Your
RTI
application.
reply.
Where is your application?
Application, I am not.
Huh?
And I am not an expert. No, I will provide it. Because I was seeking documents, my lord, sir. We are under,
That much I have understood.
my lord, we are under huge financial destitution, my lord.
That much I have understood that you have asked for information and documents.
Due to the delay, my lord, it is becoming us hard for us to survive, my lord.
Show us the jurisdiction of this court, power and authority and jurisdiction of this court to issue a direction in the nature of mandamus in the light of what has been given at page 50.
Oh, my lord, second appeal and RTI in CIC can be filed from any part of the country, my lord. It is not that only Delhi High Court will, my lord, take up the cases for early hearing, my lord, because other high courts have also issued mandamus
What kind of mandamus?
for early hearing, my lord.
Show us.
my lord.
Yeah. What is page 51?
Page 51 is, my lord, I sought the details about my application. When was my application was forwarded, my lord? Two different sets of information has been provided, my lord. to
Now,
me.
where is your application? What kind of information you have asked for?
At
And
point
what kind
number,
of reply they have given?
my lord. My lord, that's point number 3. I was told that my application is in zonal office Guwahati, my lord. But in subsequent
So
reply,
firstly, your writ petition is to be decided on the basis of the information you have sought for. What kind of information you have sought for?
I'm seeking my copy
We
of.
don't know. Court does not know. You only know.
Yes, yes.
You are the only person who knows everything. And you are not inclined to disclose that.
My lord.
By annexing the application, you simply ask for a direction to the CIC to conclude the hearing within a limited time period, prescribed time period. And you don't provide us the information which you have sought for under the RTI Act by not annexing the application.
Oh,
And you have come here for direction in the nature of mandamus to conclude the hearing of your second appeal. Is it not?
my lord, the information I requested is present in the reply.
Where is your application?
My lord.
Where is your application?
RTI application.
That is the foundation of your writ petition.
Yes, sir.
Where is that application?
Application, I'm not next month.
So you choose not to annex the application.
I will provide it, my lord.
It is up to you.
If notices may be issued.
No notice. First, you provide the
My lord.
details
My lord, my lord.
on the request of the petitioner in person, list like this, after a week, in order to enable the additional pleading for bringing the application stated to have been submitted by the petitioner in person under section 6 of the Right to Information Act 2005.
28.
Here, my lord,
Yes.
petitioner, my lord, prayed for caste status, my lord, or SC, my lord, caste certificate status, because my lord, earlier therefore fathers were, my lord, from the SC communities. My lord. In this regard, I have also annexed.
Notice of the written and either shall not be issued to provide them scheduled caste. Who are the petitioners? How many?
Petitioners, my lord, two petitioners are here before the report, my lord. Petitioner,
Declare status as claimed by your petition. Where to apply
yes, my lord.
for caste certificate?
No, my lord, they have already submitted representation because.
No,
my
no,
lord,
you have to apply perhaps. Is there any provision for applying for caste
because, my lord,
certificate or not?
there is a notification, my lord. Their father has to be, my lord, the.
No. Central government or state government must have prescribed a procedure for application.
Yes, my lord. One notification, one government office memorandum is there, my lord. On the basis of the office memorandum, we cannot be able to get because our fathers have not such type of certificate. But on the basis of the papers, my lord, because of our forefather, my lord, where the scheduled caste belongs to the SC communities, my lord. That is why I have annexed here.
Because
our father.
Article 340 and 341, perhaps. Scheduled tribes and scheduled caste orders are issued.
Yes, my lord.
Right. And with that, central government has issued a set of notifications.
8820.
How to apply for caste certificate.
Yes, caste certificate.
Did you ever apply for caste certificate?
No, my lord. We cannot be able to because our fathers.
Because if the caste application for caste certificate is rejected, then thereafter there is a provision for a state scrutiny committee
No.
who can make inquiry regarding your social status.
We have to, my lord, at the time of application for this status, my lord, we have to apply to our father's address, my lord. But our fathers denies, our grandfather denies it, my lord. But on the basis of their.
Your father denied it.
Yes, my lord. For in the matter, that is why, my lord, we have to come. Similar order.
I don't know. I'm not very accustomed to it. Will issue notice at this stage.
Yes.
Mr. Das, what you say? If the father has forgone, meaning thereby all his lineal descendants have forgone.
Yes.
Waived.
Now they want to revive.
Yes. Total list says so.
Because father thought and grandfather thought they are upward.
Well, you will have-
Upward.
Yes, madam. General
Right.
caste.
They have gone above the status of backward. Now grandfather, grandson, grandson, they say that we are backward. After being upward, they now have gone backward.
Papers, land papers, and voter list.
The
also
question is,
They'll
your
have
father not claiming, your grandfather not claiming
claiming.
backward status.
Yes, my lord.
Backward means
Yes, my lord. SC.
whatever. These are OBC, then scheduled caste, then scheduled tribe.
We vote on, my lord.
Your father and grandfather said that we are upward.
That is the case, my lord.
Yes, Mr. Das, how to come out of this situation?
And one order is also annexed here, my lord. Similar order.
Read
Similar order.
case,
Similar order, my lord.
para,
Let us
similar-
think what kind of similar order?
My lord, page 48. Of that same area, therefore fathers and land papers are also there. Because in NRC they denied.
Prescribed for issuance of physical. To submit in office among. The deprivation. Yes. This is the order you need.
Yes, my lord. Thereafter, in this case, my lord, verification was done under process, my lord. I have
Yes, what do you say?
My lord, it says, my lord, he further submits the application has to be submitted in the requisite form, prescribed in the aforesaid office memorandum.
Let them file application.
Yes,
They will consider.
Yes. It can be disposed, my lord, today itself.
S50.
Where is your marking X? Is there any marking X?
Marking X, my lord, their my grandfather also 1951 NRC they mark in cash column as mark X, my lord.
No, similar,
Similar,
same,
same, my lord.
same order.
Same order, my lord. And same area also.
Yes. Same order.
Same order.
Okay. And Goswami had and last it will go. Page 48.
Office matter then 88 put aside.
This office owner is part of it.
No, not part of it. It's a matter.
Anyway, let them decide.
Yes, yes.
48 of it. Nineteen 50 on NRC marking X.
X.
Same.
Same.
Okay, same order. Dispose of.
Timing matters. Item 8.
It will be short. It last. Last. If time permits.
Item 19.
Like your lordship accommodation, man. Madam, your lordship can see your lordship's idea got a page 133.
Oh, same order.
Yes, can be
Tomorrow.
taken up tomorrow.
Tomorrow. One already matter was hard on Mr. P.K. Roy Chaudhary, Reliance Senior Counsel, same order.
Fine.
Tomorrow.
Tomorrow.
HRS Chaudhary, Senior Counsel, and Mr. Aforesaid, Rajiv or President, please the case tomorrow.
Obliged.
Item 26.
Please, your lordship. Lord, I have a very limited prayer, your lordship. Your lordship, there is a road under Assambala project runs along with our houses, your lordship. So due to construction of this road, your lordship, heavy machinery has been used, your lordship, this has caused damage to our houses, your lordship. So that is why we filed our respective petition before the deputy commissioner as well as the executive engineer, District Hailakandi, your lordship. However, they have not taken any care of this representation till date, your lordship. My limited prayer is that, your lordship, the authorities may be directed so that they can consider our representations, your lordship. And if we are entitled after inquiry, your lordship, then they may give us compensation.
Yes.
But admittedly, no construction has been done on their land. They said that they are just nearby, and because of construction work, some damage has been caused to them.
Possible, may not be possible, we don't know.
That's true. That's true.
What do you say about this representation?
At least we may be hard, your lordship.
Huh?
Lordship.
For portion of your land was acquired.
It was also acquired.
Acquired.
Not going to
Acquired.
that aspect.
But some impact may be there, whether there is provision or not.
Let them see. No, there is no provision as such. As per my knowledge goes, there is no provision.
But it is there when suppose a part of it gets acquired. Suppose a part of a house stands on the acquired land, then if it get damaged, then the other part is also requires assessment. It is there. And they say in paragraph 3, portions of the land belonging to the petitioners were acquired by the government. So that you have received compensation for that.
we have received that, that was not adequate, but however, I have
When,
not.
but when was the project? When it was taken?
In fact, the construction
Steve,
as
sir,
Your
Councillor,
lordship, lordship,
oh, when was the project undertaken?
your lordship.
When?
It was 24,
Because that is material. That
23, 24.
year's significance.
Yes, your lordship.
When did you receive the compensation amount?
So that I have not annexed, your lordship, those documents here,
See,
your lordship, since I am
If
not going.
if the 3-4 years have gone by,
Yes, your lordship.
then this entails dismissal in limine.
Your lordship.
But if it is very recent, there can be some possibility of assessment. But if 5 years have gone by,
Representation.
no
is
question.
24, my lord.
Oh,
Then acquire must be 23.
then you have to provide the details. Otherwise, now at a distant point of time, it is very difficult to assess. We'll not go for fishing inquiry.
That's true.
Your lordship, my limited prayer is that your.
No, limited prayer. I generally don't dispose of any repetition for disposal of the representation.
Your lordship.
I have made it aware to all.
Not your lordship.
Your lordship.
This is not a court for representation disposal order.
I beg pardon of your lordship.
I am making it clear. Very rarely I pass such order.
True.
Unless I get myself satisfied.
Your lordship.
When is your representation?
It starts from page 17. Your lordship.
Page.
Page 17, your lordship.
17.
January 24.
To 20/01/2024.
Yes.
2.5 years.
Your lordship.
Now it is very difficult to assess.
And
So it requires entails dismissal.
I may be allowed some time, your lordship, so that.
You come up with better particulars, but here on the basis of these facts, I'll dismiss. Because it is very difficult to assess now what is the impact of the road construction,
2.5 years.
right? You have waited for 2.5 years. How can now they assess?
Immediately, your lordship.
Is it possible?
No, immediately, that is why your lordship.
Come
will
up
find
with
out
better
representation,
particulars,
your lordship.
otherwise I am not with this scanty details. This court does not want to enter into all those.
We filed our representation immediately, your lordship.
That does not give you any license to wait for 2.5 years.
Your lordship, one representation is also, your lordship, later on we filed our
That will
representation
not
before exhibit.
extend the period of limitation.
When was the land acquired?
In fact, they have just said that house and shop has been damaged. Nothing, no further particular, no further detail is given.
Then when land was acquired, it was.
Nothing is there.
Nothing is there.
So
You
I may
come
be
up
allowed
with
some
better
time,
thing.
your lordship. I may be allowed some time so that.
No time. I am dismissing it. Otherwise, you withdraw and come up with better particulars.
Maybe, your lordship.
It is up to you.
To tell
Come
you
up
what
with
you-
better particulars.
Maybe, your lordship.
That we have received this much of compensation and these are the impact. Something like that. Otherwise, there is nothing.
Your lordship.
Why I should make an direct the respondent authorities to make an assessment when it is not possible? Heard Mr.
Yeah.
E. Ahmed, learned counsel for the petitioners. Mr. Revenue, aforesaid, Revenue 1, G Nath
2 and 4. No?
2 and 4, standing counsel PWD and Das
3 months.
3. Full stop. Mr. Ahmed, learned counsel for the petitioners has submitted that petitioners should be allowed to withdraw the petition with the liberty to file afresh with better particulars. In view of the above submission made by Mr. Swain, the petition dismissed on withdrawal with a liberty as prayed for. Come up with something more.
Lordship. Oblige, your lordship.
Item 31.
A.M. Borbuya. Yes, Mr. Borbuya.
Please, Lordship. My lord, in this matter, my lord, the same party, my lord, filed earlier, my lord, 3 cases, my lord. Where we are, my lord,
In the connected petition, You are respondent or you are not respondent?
Lordship,
For what relief the repetition was filed?
my lord, they are saying that, my lord, this road is going through their land. my lord.
Not to construct the road over the land of the petitioner. Not to change nature and character of the suit land. And they are seeking direction to the state respondents.
Yes, my lord. Lordship, kindly have a look in their writ petition on page 24, my lord.
24. Yes.
Page 21, my lord, in this, their title suit, my lord, we are, my lord, made party respondent, my lord.
Huh.
Hussain Ahmed and Jainul, my lord, first and second, my lord.
Hmm.
Then, my lord,
Why the title suit is?
my lord, this is title suit, page.
What relief?
Same, my lord, for not to construct, my lord, land, the road, my lord.
Let us see the prayer. So one of the scheduled inheritance unrenewed by the inheritance corporation.
For page 33, my lord.
Declaration of right, title and interest and confirmation of possession. Illegal activities of principal defendant state in appraising. Yes.
My lord. My lord, the case of the petitioner, my lord will kindly see the order dated 11/2/2026 in the order sheet, my lord. That will clear up the facts, my lord. My lord is confused, my lord.
Yes, Mr. Nath, any proposal for construction of land?
No, my lord, my instruction, I have received the instructions, my affidavit is, my lord, I'll file the affidavit shortly. Only the survey work has been done. No final decision has been taken at this stage. Only the preliminary survey, because under the PMGSY 4 guidelines, the land has to be ultimately given. It is to connect the habitable where the connectivity is not there.
But as on date, whether any proposal or something like that,
No. Only survey has been
when
done.
can you file the affidavit?
My affidavit is ready within a week, my lord will file.
If the repetition falls, there is nothing remains.
Nothing remains. True.
And my lord,
If repetition itself,
in fact, my lord, if your lordships kindly see,
then let them fight in the title suit. If there is no proposal for acquisition of land,
already
the
title
question?
suit is going on, my lord.
Just because
Yes.
some person have visited the site, that does not mean that any decision for
Yes,
proposal.
my learned client has no locus to file this instant IA only on the ground because my
It seems
contention.
that the petitioner has no locus also.
No, my lord, because
No cause of action.
Dag number 78, this present petitioner's father purchased the plot of land connected to Dag number 78. My learned client is connected to Dag number 140.
No, Mr.
Now the proposal,
Mohammed, if
yes.
there is no decision
Yes,
to acquire any land for construction of any road,
yes,
the petition itself will fail,
my lord.
right? Then there is no question of
In-
deciding the I also.
My lord.
If
In fact-
Mr. Nath comes up with that
Yes.
affidavit,
Yes.
that as on date, There is no proposal for
Yes.
acquiring any land and construction for construction.
In fact, under this particular scheme, acquisition will not be there. Well, this particular scheme says that if the land is given voluntarily
Yes.
for the PMGSY scheme, then only the
Then-
road will be constructed.
Correct.
Then file the affidavit shortly, we'll
Yes, yes.
decide both.
Yes, on that ground only it can be disposed of.
Full submission is there, my lord. They have filed their own case, my lord. In earlier three, my lord, cases, we are made party, my lord.
Let Mr. Nath
Well,
file the affidavit.
Well,
1 week you file, then we'll decide.
yes, we did.
IA as well as if the writ petition survives,
my lord.
your IA will be decided. If the writ petition does not survive, then you are a parasite.
My lord.
In fact, verbal instruction was placed. This honorable court directed them to file an affidavit so that on that ground it
I have
can be
understood.
disposed of.
Let
Yes.
Mr. Nath,
My lord.
you have received instructions.
I have received. I have received. My lord.
Your IA will be kept pending.
My lord.
Heard Mr. A.M. Borvian Learned Counsel for the applicant in IAC number so and so. Mr. K. Mohammed Learned Counsel for the petitioner in WBC number so and so. And Mr. D. Nath Learned Standing Counsel for Public Works Department for the state respondent and Mr. Any government advocate. So Mr. Nath has submitted that. He has received the necessary instruction to file the counter affidavit on behalf of the state respondents in the Public Works Department. And the same can be filed within a week's time.
Lord.
Post in he has therefore shortlisting of the case after 1 week. Post it is submitted that in as the counter affidavit on behalf of the respondent PWD is to be filed or is going to be filed within a week's time. Let the case be listed in the same column on Wednesday, next Wednesday.
22nd.
Lord.
Oblige.
Honor.
Unless there is an interim order, it will.
The interim order passed idea shall.
I'm deeply.
Item 33 for admission.
Order. 33. Ayada আছে নেকি চাওঁ? Ayada. There is IA. IA is for what?
IA is for implement of NHI DCL, your lordship.
Okay. Yes, we'll allow. Heard Mr. M.H. Roskor, Learned Counsel for the applicants. Mr. R.K. Talukdar, Learned Standing Counsel. And HIDCL for the opposite party number 1.
And lordship.
2.
6.
That will be proposed. That will be proposed. And Mr. H. Sharma, Learned Additional Senior Government Advocate for the respondent number, opposite party number 3, 4, and 5. Post of para. The applicants as the writ petitioners have preferred the connected writ petition WBC number 5497/2025. Post of. In the writ petition, the applicant petitioners have claimed that they are landowners of a parcel of land which have been brought under the purview of a land acquisition purview of land acquisition under the provisions of the National Highways Act 1956 for a project building within bracket widening, stroke 4 laning, etc. Bracket close, comma, maintenance, comma, management and operation of NH -306 in the stretch of land from KM so-and-so to so-and-so in the district of Kachar, the project for salt. Para, the instant application is filed seeking implement of the following authority. Respond number 6(2). As party respond number 6 in the accompanying repetition on the premise that the implementing agency for the project is the proposed party respondent, and as such, for adjudication of the issues involved in the connected repetition, the presence of the proposed party respondent is necessary. Full stop. The learned counsel appearing for the opposite parties have submitted that they have no objection if the instant application seeking inclusion of the proposed party respondent number 6 is allowed. Full stop. As the proposed party respondent is the implementing agency authority for the project, this court is of the considered view that presence of the proposed party respondent is necessary for adjudication of the issues involved in the repetition. Accordingly, the instant application is allowed. Full stop. Herit লিখিব petitioner. MS Law Court petitioners by any লিখি দিব. In view of the order passed today in IAC number 1889/2026, Mr. Loskal, the counsel for the petition shall submit an amended cost title before the registry in terms of the notification dated so and so. Within a period of within 3 working days from today. So stop. Absolutely, on submission of so and so. Necessary correction just CS so and so, and release the case on so and so next week.
2407, 24
Item 34.
My senior has been delayed and stuck somewhere due to the heavy rainfall outside, so I'm appearing on his behalf. Lordship, as per court order, we have already filed our affidavit in opposition. Let the government file their reply. Till that interim may be continue, Lordship.
Okay. Lordship, but this case, they have challenged a notice dated 12/1/2026, eviction notice, man.
12/1. Which page?
So, yes, need to.
What kind of interim?
They are
Eviction notice.
eviction notice.
Page annexer 1. Annexer 1. What kind of interim order?
Interim order was somewhat, my lord, that
What is
without the
interim
leave
order?
of the court, we cannot evict them. And we had filed our affidavit.
Huh.
In the affidavit, we stated that they are all encroacher of government land.
Interim order is that the process of hearing by the circular officer pursuant to the notice is underway. No specific order have been passed. We permit the respondents to proceed the hearing.
Hearing
But
was
no
done
final order be passed without leave of the court till the next date fixed.
till then.
So that is
No, hearing was
somehow
over.
it is
Hearing was over.
hearing is
And
over.
they have
Only the
attended.
speaking order is to be passed.
My lord, no speaking order, they could not produce anything.
No.
That's what my instruction is.
No, the law says that if such kind of notice is there, first order, 28/1/2026.
28 okay. It would notice.
Process of hearing was underway.
No.
And an order is to be passed in terms of Salakuddin.
Man,
So court has restrained
unless the hearing is.
no final order without leave of the court.
Right.
That is the only final order. So thereby, due to a pendency of the writ petition, the final order could not be passed.
Yes, ma'am. It could not, but hearing was over and they attended, they could not produce anything that.
If the final
documents are
order is passed, that is a subject matter of challenge.
Yes. Final order
Again.
could not be, we could not pass. Final order.
Because of the interim order, you could
Mine,
not pass.
mine.
Yes, what do you say?
Lordship, my senior is not present today, so matter maybe pass over timing. I'm under his.
No timing.
instruction
No timing at 3 o'clock.
For the next set, Lordship.
Okay, next Monday.
Mine.
Obliged, Lordship.
Heard, Mr.
Arif Khan, Lordship. Arif Khan, on behalf of Jit Khali.
Yeah, copy ko hai.
Learning Council for the petition. Vijay Talukdar. Raised by Mr. P.K. Mehti, 135, and Borule, Standing Council, Revenue 2. And as briefed by Mr. So-and-so, Learning Council for the petitions, release the case on Monday, next Monday.
Obliged, Lordship.
Item 38.
The responded to.
Affidavit file.
No, Lordship, waiting for instructions, so kindly.
ABT Hawk, Learning Council for the petitioner is present. Ms. N. Boral, and Standing Council, Conservation and Rural Development Department has sought further 4 weeks' time to obtain the necessary instruction and to file the counter affidavit. Also, the prayer is not opposed by the Learning Council for the petitioner, lays the case on so-and-so. The prayer is allowed, lays the case on so-and-so. The interim order, any interim order,
No.
if any, shall continue till the next day of this.
10th August, 1008. Item 39.
In this case, Lordship, notice was issued by the Honorable Court. Today is the returnable date, Lordship.
Lordship, I have not instruction, but here, Lordship, they have challenged the order in original after 2 years. And no appeal has.
Do you intend to file any affidavit?
Yes, Lordship, we will receive, and they are going to send us the instruction, Lordship. Lordship, may allow me a short time, Lordship.
Short time.
Yes.
We will decide.
Other matters were fixed on 10th August, Lordship.
No, we will not go to that distance. We will decide it. File whatever you want to file.
Yes, ma'am.
Within 1 week. SK Agar for the petition is present. Mr. B. Chaudhary, Land Standing Council, Finance and Petition Department for all the respondents has sought for each time to file a short counter affidavit. On the law points.
Yes,
that's
ma'am.
all.
Yes, ma'am.
The praise the Lord. As sought for Mr. Chaudhary, is the case on. Today is
13.
July. 27 July.
Yes, ma'am.
Same.
Same, Lordship.
Same. 40, 41, 42.
Obliged, Lordship.
For orders, items 43 and 44.
Please, Your Lordship, against the IA filed with the respondents, will be filing a reply.
Oh, IA is not yet. No order has been passed. till
No
now.
order has been passed.
Will be filing a reply.
They want to file objection. I think.
Look into the IA first.
Yes.
Court has not looked into the IA till now. What is this? IA?
Lordship, this I is filed by the NHA, Lordship, seeking extension of time, Your Lordship.
Where is that order?
Order is
2026.
Annexure 1, page 25, Your Lordship.
Yes, 25. How much time?
Lordship, para 6 of my affidavit. May I read the Lordship? It is to submit it respectfully that the apex court in the judgment and order dated 25/3/26 passed in review petition number so and so, miscellaneous appeal number so and so, arising out of civil appeal so and so, was pleased to grant solicium interest in the affected person and also give direction regarding the person who are to be considered for payment of solicium. Now, in terms of the direction issued in the aforesaid judgment and order dated 25/3/26, the apex court, the issue has been taken up by the NHA with the mode and a standing operation is under process. And to the issue sought for implementation of aforesaid judgment and order dated 20. Now,
Extension of time cannot be indefinite.
that's it.
You may take years to prepare the SOP,
No, Your Lordship, sir.
right? It can be, say, extend by
It is
2
under
weeks or extend by 4 weeks, okay.
That's it.
But
It is
this application is indefinite. You'll prepare after consultation, SOP after 2 years. Court
As
has granted
as per-
time till 22/5.
as per your
And this Tarsem Singh was disposed of on 25/3.
yes, Your Lordship.
It is already more than 3 months. You have not been able to prepare the SOP.
That much,
And we cannot extend it indefinitely.
Lordship, obviously, Lordship.
So court cannot grant indefinite time, so I am dismissing it.
Lordship may. Or they did not.
See the prayer.
Yes, Your Lordship, I have seen the program.
Once court has fixed a time limit, right? Page 20, you said, page 20, 2 months. Right?
Lordship.
Extension at best could be for further 2 months.
2 months.
Or less than 2 months. It cannot be indefinite.
Lordship may, as Lordship this record for
Who
2
has
months.
filed? Mr. Burua.
Lordship,
Burua is available.
he is available in code number 13, Your Lordship. He is
Tell him
available.
to rush to this court that this IA is to be dismissed now.
Hello.
Inform him.
Okay.
Item number 44, I am agreed.
Same application or what?
No, this is not same application.
Ah.
Similar matter, that was dismissed by your lordship. That Deepak Kumar Patgiri. What happened in earlier case, they were
44.
asked to file a additional affidavit,
44.
44. Same petition, lordship, nothing, no changes there. Same petition. Deepak Kumar Patgiri, 1566. Then the same petition, this is also.
I'm not getting it.
Yes, lordship.
Item number?
Item number 44. But in,
44.
yes, in WPC number 1566, your lordship has directed them to produce an additional affidavit regarding that they are the member of
Item number 44 is Gupi Saha.
Gopi Saha.
Ah.
I am appearing in that case. Earlier case, I am not appearing. But similar case was dismissed. They have withdrawn the case. It was about to dismiss they have withdrawn the case. That in that case, lordship has directed to produce to file an additional affidavit regarding that. In Gopisa also, they have mentioned that petitioner is a member of Bijli Mohukuma Khatigrasta Pattadar Sartha Rekha Samiti. So lordship directed, you are the member of that committee, then file an additional affidavit that you are the member. You prove the same. So they could not file so they have withdrawn the case. Same
But
petition. But this
Kanduri Bala Roy.
that is different, lordship.
This is Kanduri Bala Roy. Here the IA is.
Same.
IA is in Kanduri Bala.
But I am 44. Item number 44.
Why it is that? List the.
This is the same matter.
But now that was dismissed by your lordship.
That I don't know the order, what, under what situation I have dismissed.
Yes, I can show the same petition. lordship.
Huh?
I can show the lordship the same petition there.
Reflected in the list. Gopi Saha's name is reflected in the list.
Gopi Saha.
That is.
Gopi Saha is state, was it?
Gopi Saha, Kalluri, that is different case.
Different
Because,
case. They are saying that is different case.
Bisdi Mohkuma Kotigrosto Patadar.
Kotigosta.
Earlier was, or what?
This is lordship.
No,
earlier.
which petitioner's case was dismissed by this court?
Deepak.
May I just?
Ah.
Lordship, what had happened earlier, these petitioners had approached through a society, had approached before your lordships in 2017. Your lordship has passed an order to give a solicium amount and interest, etc. thereon. If lordship take the earlier, I had only the brief of the earlier case. Earlier case, lordships, if the take lordship's judgment is of dated 23/5/2017. In 2023/5/2017, lordships. In that case, lordships, petitioners through a society had approached before your lordships. And your lordship has directed them to individually approach before the authority, file a representations. Accordingly, they had to decide. Lordship, thereafter, lordship, they had decided and they had paid the amounts to some of the petitioners. Lordship, what had happened thereafter, the allotment has been given. Allotment of money has been given regarding these petitioners, Kandriwala, etc., etc. If lordship takes the petition,
But
page,
not this petition.
page 43.
Which petition now?
Earlier petition, since I had the earlier petition only. lordship.
I don't have that. How can I take that?
But they were not directed to pay any compensation. This
No,
Gopi
it was
Saha.
directed.
We are into the IA today, which entails dismissal. We are into the IA.
But this case is different. They,
Let the IA be decided.
yes, yes.
Next. After some time, let Mr. Borwa come.
45 and 46.
There is an
Treatment.
interim
Who is to be
application.
implemented?
Madam, chairman is implemented, madam.
Hmm?
Chairman of the society.
Chairman of the society. Okay. Yes.
Lordship, item number 46, I am appearing for the respondent number 7.
Oh, what about the IA?
I is for the implement.
Hmm.
45.
Yes.
So that copy I do not receive, Lordship. For implement.
Chairman, you are representing whom?
Chairman. In 46, I am representing chairman. Respondent
In
number 7.
46, you represent chairman. Now, he is seeking implement of chairman as a party respondent in this petition, this IA.
So that copy I do not receive. Lordship.
I think she is not in this case, but she is in 46.
Yes, but
We allow this. Heard Mr. R.P. Sharma, Learned Senior Counsel. Listed by Ms.
A Deka.
A. Deka, Learned Counsel for the applicants. Register cooperative societies. You are for secretary, Mr. A.S. M.I. Hussain. And Mr. M.I. Hussain. Learned Counsel for the opposite party number 5. The Learned Standing Counsel. Cooperation Department is found for the opposite party number 1, 2, 3, 4 is found absent today on call. The applicants as the lead petitioners have preferred the accompanying lead petition. WPC number 4919/2025. Raising certain allegations against the chairman of Kurua Homobai Homiti Limited. Full stop. The applicants petitioners, their petitions have stated that they are shareholders of Kurua Homobai Homiti Limited. Full stop. Para. The instant application is preferred by the applicants petitioners seeking implement of the following authority. To is Porot, is and Kurua so and so. As party respondent number 6 in the accompanying petition. So it is about that without the presence of the proposed party respondent number 6, the adjudication of the issues would not be complete. Involved in the petition would not be complete. Full stop. Para. As the applicants petitions have stated that they have preferred the accompanying petition raising certain allegations against the chairman of Kurua Homobai Committee Limited, and the instant application is preferred seeking implement of the chairman Kurua Homobai Committee Limited, the application stands allowed. Next, I heard Mr. R.P. Shaman as senior counsel stated by Ms. So-and-so and Ms. So-and-so.
B. Shaha.
B. Shaha, learned. Counsel for the respondent number
7.
Oh, you are not here.
Not.
Wait.
Only in 45, before you also,
So-
before you also goes to 46. In 45.
Just a
I'm
minute.
allowed to take
We are dealing with 45.
45.
We are dealing with 45. Estate by Ms. So-and-so. The Alliance Standing Council. Cooperation Department. For the respondent number 124 is found absent to the call. And Mr. M.I. Hussain, learned counsel for the respondent number 5. So, in view of the order passed today in the in ISC number so and so, the learned the petition shall file an amended cost title before the registry within 3 working days from today, and on submission on filing of such amended cost title, the registry is to carry out the necessary corrections in the cost title of the petition as well as in the CIS. So thereafter, the case be listed on so and so, along with WBC number 5018/2025 on so. You be there on the next day. You have to accept notice.
You will have to take this on
After amended cost title.
24th July.
Then only I can issue notice. So next date of listing I am giving.
2407. Item number 47.
My lord, in this case, my lord, I am representing respondent number 1 and 2, my lord, HDFC Bank. We have filed our affidavit. My lord, we have received one communication from the cyber helpline, my lord, cyber police from Gujarat, saying that, my lord, putting a hold on the lien amount, putting a lien on the disputed amount, my lord, the entire account may be released, my lord. That's what we have received the instruction, my lord. We have accordingly filed our affidavit.
You have
My lord.
filed any instruction?
Yeah, I have filed an affidavit, my lord. Page 58, my lord.
Page 58.
Yes, ma'am.
Annexer?
This is Annexer E, my lord.
Okay, that is at page 61. So where is the statement?
Para
Paragraph?
11, para 11, my lord.
Yeah. So, keeping a lien on 330,
Yes,
rupees 330.
Yes, yes, Lord.
Heard, Miss
VC Besburger.
PC Bezura learned counsel for the petition. And Mr. R. Chakravarti learned counsel appearing for the respondent number 1 and 2. Close to. And Mr. A.K. Dotto learned counsel for the respondent number 7. 7. Close to. In this petition, instituted under Article 226 of the Constitution, the petition has assailed action on the part of the respondent number 1 and 2. Respondent HDFC Bank authorities in freezing her account bearing number savings bank account.
Savings bank account.
Savings bank account number. Era 1 of 502 maintained at KB Road branch, Gauhati, Assam of the HDFC Bank Limited. So stop. It is the case of the petitioner that action on the part of the so-and-so. Respondent HDFC Bank authorities in freezing her savings bank account number so-and-so, maintain it so-and-so, so-and-so. Post office. It is the case of the petition that the petitioner
Current.
has a deposit of about of more than 18 lakh in a said savings bank account, and due to an alleged suspicious transaction stroke credit of rupees 310, the entire account has been kept debit faced by the respondent authorities. Post of. Notices were issued to the respondent authorities, including the respondent number 1 and 2 on 29/4/2026. And Mr. Chakravarti learned R. Chakravarti learned counsel for the respondent number 2. And had entered appearance and filed an affidavit in opposition, filed a counter on 20/06/2026. Mr. Chakravarti has submitted. So current account,
Current account, please. Sorry.
has submitted that It was on receipt of complaints. 3 complaints.
Yes.
Yes. One from Cyber Crime Police Station, Andhra Pradesh, NTR Commissionerate. One dated 18/9/2024. And 2 complaints it was in view of a receipt of number of complaints regarding suspicious transactions in the bank accounts of the petitioner, the account was put on debit freeze, WEF 20/01/2026. What about Andhra Pradesh? Anything?
That is also settled.
Full stop. In the affidavit, counter affidavit filed on behalf of the respondent number 1 and 2 and Mr. Chakraborty. Mr. Chakraborty and counsel appearing for the respondent 1 and 2 has submitted that the issue raised in the complaint received from Andhra Pradesh NTR Commissionerate has since been settled.
Yes, sir.
Insofar as the complaints received from the state of Gujarat is concerned, a communication has been received from the Superintendent of Police, Cyber Center of Excellence, Gandhinagar, Gujarat. Communication dated 11/6/2006. Post up. In the affidavit of position, it is averred that on 11/6/2026, the bank, through its centralized LEA department, page 54. Oh, I'm sorry. Para 11, right?
Yes, but para 11.
Department received an email along with a notice from the Superintendent of Police, Cyber Center of Excellence, Gandhinagar, Gujarat, requesting the bank to mark a lien for an amount of rupees 330 and to release the entire amount in the petitioner's current account number 50200026001871. It is further heard that acting on the email, the bank branch replied back informing them about the pending case. It is not required. Not required. Full stop. Para. Having heard and considered the submissions made by the land council for the parties, this court is of the considered view that the action of the respondent bank in keeping the current bank account of the petitioner freeze for the entire amount is not sustainable to the extent that it exceeds the scope of direction received from the investigating authorities from the state of Gujarat. Full stop. The power exercised by the respondent bank is not an independent power. Full stop. The bank, apart from implementing the direction made by the investigating authorities, also acts as the custodian of the bank accounts. Full stop. Though it is submitted this court is of the considered view. Having considered the entire aspects of the matter, the writ petition is allowed to the extent that the debit freeze stroke withholding instruction made by the investigating authority for the amount of rupees 330 is to be executed by the respondent bank authorities by keeping a lien over the said amount of rupees 330 at this stage. So submitting thereby, the respondent bank authorities shall restrict the freezing order operative over the petitioner's current bank account number so and so only to the extent of rupees 330, and the petitioner is to be allowed to operate the current bank account in respect of the balance amount lying credited thereof, subject to any further instruction made permissible under the law by any competent authority in accordance with law. The writ petition is allowed to the extent indicated above, no cost.
Always.
48.
My Lordship, in
Yes.
this case, the petitioner number 1 expired. So in his place, our wife filed an application to get her.
Part Mr. A. Dasgupta Lines in house estate by B. Das. Learned counsel for the applicants.
Timothy Ajuli Rai.
No, I am looking at the cost title.
Huh.
And Mr. R. Boru.
Lordship, on behalf of
Learned counsel on behalf of Mr. C. Borua.
Lordship,
Learned standing counsel
for
NHAI
Lordship,
for the
4 and
opposite
6.
party number 1 and 4.
4 and 6. Your Lordship.
One also?
One of
1, 4, and 6. Mr. Aforesaid, standing counsel, Revenue Department for the opposite party number 2. And Miss M. Bormon, learned junior advocate for the opposite party number 3, 5, and 7. Para. The applicants are the writ petitioners in the connected writ petition WPC number 187/2020. Para the instant application is preferred. Seeking substitution of the petition number 1 as the petition number 1, Jadhav Roy had expired, during the pendency of the writ petition, on 28/6/2020. As the right to sue survives, and the petition, the applicants have sought substitution of the petition number 1 by
substitution.
by his 2 legal representatives. Roman 1 small, Timothy Ajuli Roy, and Roman 2, Sri Pankaj Roy, who are the wife and the son respectively.
Actually,
Of
his
the-
son is a minor.
Okay. So only one.
Only one.
Auxilia, who is the wife of the petition number 1, within bracket, since diseased, Jadhav. So the land council appearing for the opposite parties have submitted that they have no objection if the instant application for substitution is allowed. Post of having regard to the fact that the right to sue survives for the petition number 1 since disease, and substitution is to be substituted by the legal representative. Srimati Anjali Roy, who is the wife, who is his wife, the instant application is allowed. Full stop. I think cost title is to be submitted.
Yes.
In the main writ petition. আর Mr. A. Das Gupta, and senior counsel estate by Ms. B. Das, by লিখে দিব respond number particular. In view of the order passed today in IA number so and so, ISC number so and so, the general counsel for the petitioner shall file an amended cost title. Within so and so, so and so.
Next to me.
Correction, yes, yes. Yes, anything, affidavit filed. All affidavits are filed.
We have filed.
They're filed. Any respondent? No. Any other respondent?
No record, not record.
Not required.
It's not required because their affidavit will cover regarding that safety of
Okay.
SOP.
Okay. Lays the case on first. We'll post the date.
My lord. I'm sorry that another case before, case was there.
Hearing date, no, on admission date, যদি rule হয়েছে, raise the case on so and so in the appropriate column.
Itu case ni?
5907.
Between no, no.
Let us finish.
Oh, yeah.
Thereafter we'll hear you
Oh, yes, my lord.
in leisure.
Items 49 and 50.
In item 49, Lordship, I am paying for a small adjournment, Lordship, for next week.
Okay, on the request of Mr.
I need some time to file objection, my lord. So 2 weeks time may be granted, my lord. In the IA, my lord.
Okay, Mr. ABT Hawk, learned counsel for a petition, Mr. M. HR Ahmed, learned counsel for the
Opposite party.
opposite party number 1 and 2.
1 and 2.
Have both could have sought for listing of the case after 2 weeks. Mr. Ahmed has submitted that he'll file an objection
My lord.
to the instant application within 2 weeks' time.
Obliged, my
And
lord.
thus, you were there, Mr. Endas, learned counsel for junior government advocate for the state. Respondent is filed.
After 2 weeks.
Raise the case on switch.
Obliged, my lord.
3rd August 0308. Item number 51.
Just a minute, let me read. Will allow.
Yes, Lordship, and even the opinion also says that, but one.
At-
bulk
at-
there-
3 and 44.
Second. Last second. Second one, you know. Give some more thought in the book. Yes,
My lord,
2 months time was given.
No, too much time, Lordship is kind enough to give time, but this is 25, 2000.
No indefinite time.
Right, this Supreme
It
Court.
must be either 2 months or less than 2 months. It cannot be more than 2 months.
That is your Lordship, please, Anna, I cannot say.
No, it cannot be.
No, that's, I have understood.
Can it be a
Because.
logical?
No, they're not
Logical.
logical.
Can it be logical?
No, no,
First
that-
you seek time for 1 month. Then suppose court has granted you 2 months. Now you filed an application without any time limit. Can the court give extension for 6 months?
Certainly not, my lord.
Not.
But-
Then 1 year.
but-
It cannot go on increasing.
No, but what happened, my lord?
And otherwise also your application is to be dismissed because extension application is to be filed within the
No,
period.
that's correct, my lord.
And I have checked.
Yes,
Your
See-
application is beyond the extension period.
but whatever.
So this entails dismissal otherwise.
No, whatever, my lord, because this SOP.
I don't know.
We are
That
not.
I don't know.
There is a Lordship, the Lordship is saying 2 months maximum. Lordship may grant.
Yes, man.
Lordship, it's a matter of 2017.
Anyway, it carries interest or not? It will be compensated. 2 months only. We'll not go into all this same thing.
No, not required also. We are praying only for, because still SOP, our prayer was still SOP, because SOP is prepared by ministry. So we are not preparing, because it is to be given effect to all India, entire nation. We are paying, not only this. That is why standard operating procedure has been prepared.
No,
And it is also submitted.
Mr. Borua, you have undertaken 23/3/2026. You made the undertaking that this benefit will be granted to the petitioners on or before 22/05/2026, irrespective of SOP.
That's why, my lord, that's why I'm not going beyond that.
Ah.
Yeah.
Don't go beyond that.
We have,
Because Tarsem Singh happened
we
when?
have to happily accepted your lordship. This one.
No, Tarsem Singh happened when?
25/3/2026. Final
25/3/2026.
26.
Where is
What
the
happened, my
order?
lord? That was Tarsem Singh. What happened? Initially, WBS was filed. They have given, again, it was been reviewed. Second time
Ah,
also,
that,
it is not cleared. Until finally, it
Tarsem
is.
Singh was originally rendered by Justice Nariman.
Then ultimately, my lord, this order was just come up, aforesaid 25/3/2026. Got finally dated. Tarsem Singh has got.
Miss,
Dear Bangshir.
oh, and Mr. C. Boro. Last Standing Council, NHAI.
Lordship, I kindly report that no further extension shall be provided beyond 2 months.
That is court decision. Miss
Dear Bangshir.
D.R.
Bangshir. Bangshir.
Bongsiari.
Bangshir, BONGSHIR.
B.O.N.
GSHIARY.
Learned Counsel for the opposite party number 1 to 12. 1 to 12? Check.
Yes, Lordship.
To applicants. Mr. Aforesaid, then Standing Council Revenue Department, Government of Assam for the opposite party number 13, Miss M. Burman and Junior Government Advocate Assam for the opposite party number 14 and 15. So the applicants hearing, the 4 applicants hearing are included as respond number 1, 4, 5, and 6 in the accompanying petition. Top DPC number 3496/2020. Close stop. Para. In the accompanying writ petition, wherein the opposite party number 1 to 12 are the writ petitioners, comma, has been filed seeking inter alia direction to the respondent authorities, comma, more particularly, comma, the respondent authorities in the National Highway Authority of India,
Yes, sir.
to grant the benefits in the form of solatium at 30% and additional compensation at 12% under section 23 within bracket 2 and section 23 within bracket 1 capital A of the Land Acquisition Act 1894, right?
Mm.
Since repealed to them as their lands have been acquired by the under the provisions of the National Highways Act 1956. Full stop. In the course of the proceedings, comma, the court on (23/3/2026) recorded an undertaking of the learned counsel paying for the respondent NHAI authorities to the effect that the respondent authorities in the NHAI would extend the benefit of solatium at 30% and interest at 12%, along with interest accrued thereon on or before 22/05/2026 to the petitioners. That is the applicant's hearing. Sorry, the opposite party number 1 to 12 hearing. Post of para. The instant application is filed by the applicants seeking extension of time to abide by the undertaking given on 23/3/2026 and recorded in the order dated 23/3/2026. Full stop. Para. Mr. Borua, learned counsel appearing for the applicants, has submitted that after disposal of a review petition from a review petition within bracket civil number 2528/2025 in miscellaneous application number 1773/2021 in civil appeal number 7064/2019 within bracket the National Highways Authority of India versus Tarsem Singh and others. Bracket close, page 26 of this. On 25/3/2026. comma, the central government. Sorry, the issue has been taken up by the NHAI with the Ministry of Road Transport and Highways, MORTH, comma, Government of India. And a standard operating procedure, SOP, is under preparation. So it is about that only after the SOP, which is presently under preparation, comma, only after issuance of the SOP, comma, which is presently under preparation, comma, the implementation of the order dated 25/3/2026 is possible, and for it can be is to be abided by, and citing the same, comma, the instant application seeking extension of time has been filed, post of para. When the order dated 23/3/2026, sorry, the time limit of about 2 months was about 2 months up to 22/5/2026 was recorded by this court on the basis of the undertaking, on the basis of the submission made by the learned counsel appearing for the applicants, that's respondent authorities in the NHI, that the benefits of solicium at 30% and interest at 12%, along with interest accrued thereon, would be extended to the petitioner. Full stop. A period of extension, full stop, in the instant application, this court, it is noticed that no fixed time limit for extension has been sought for. Whereas on 23/3/2026, a time period of 2 months was sought for. Post. After seeking a time period of 2 months on 23/3/2026, comma, an application seeking implementation of the direction seeking extension of time period of indefinite nature, comma, in the considered view of this court, it would not be, comma, would not be tenable. At this stage, Mr. Borua, land counsel appearing for the applicants, has submitted a period of 2 months. But from 22, already 2 months is about to pass.
For ends of justice, because it is, matter is a greater interest for it, not only it is.
As I said, 2017, your lordship has directed. So within 3 months, they have to pay.
Greater interest meaning I am not only this, we have to pay to all entire affected person of India.
He has submitted that, public, at least this, Mr. Borua. Council is paying for the applicants, have submitted that. Though the application was submitted, filed in May 2026. The application has been listed for the first time today. And a period of 2 months from today would be reasonable and sufficient for the applicants to comply with their direction made in the order dated 23/3/2026. So, but having found the submission of the Land Council for the applicants regarding the extension of time period reasonable, the instant application is allowed. First of the applicants, that is the respondent authorities in the NHAI, in the accompanying petition, are allowed to comply, allowed to extend the benefit of solution at 30% and interest at 12%, along with interest accrued thereon on or within a period of 2 months from today, that is on or before. Today is 13. (13/9, 2000). Oblige 26. Uh,
44 lordship.
44.
Lordship,
It is tagged along with that.
Yes,
Let it be listed after.
Let,
It did you 44 did you Mr. 44 to you code go to I है
44. Different petition.
Who is the petitioner? Gopi Saha. Who is the petitioner? You are the petitioner.
Yes.
Gopi Saha.
Lordship, she is representing lordship. I am just in the.
No, who is the petitioner? Dear Bangshiri Land Council for petitioner and Miss R. Bora Land Standing Council NHAI and A. Gayon Standing Central Government Council A. Aforesaid Revenue M. Bormon. We are not recording. Are present for the state respondents are present. Post list the case as sought for by the Land Council for Parties. List the case on give it date along with WBC number 3496/2020.
With the same direction, lordship. With the same direction, lordship.
No, there is no I. Why should I pass order?
What happened the same lordship may kindly list this matter along with the dispose of metal.
No. I am coming to that then, lordship. Lordship, may I place?
Why?
No, I will not apply my mind now.
But WPC number 1566, 2026.
That was disputed.
But similar matter. They are not entitled to get the
Okay.
compensation, lordship.
Office
That's
to
why.
list
No,
the
that-
cases along with the
withdrawn.
records of WBC number
1566.
1566.
Withdrawn হলে তো dismiss হয়েছে, আপনাকে
One, tell me the number.
1566, lordship.
Of which year?
2026.
That was already been withdrawn. How can lordship? It was
Court can pass order.
I'm not. That,
Because
that was already withdrawn.
As sought for by Mr. R. Bora.
Yes.
Land standing
Because they were directed to actually to file an additional affidavit regarding their claim. That's why they have withdrawn the case.
This is, this case actually tagged with this because of the similar factor.
After vacation, I have no seminar today. It's like Thursday. Just before vacation, we have disposed of one revocation application.
My
and
lord.
all. What is the case number?
Case number, Lordship will provide it.
I'm providing that number. I have the order also. I will provide one.
Case number লিখি ল'ব আৰু এইটো অৰ্ডাৰৰ এটা কপি এটা সোমাই থৈ দিব RS মিশ্ৰ নামে লিখি দিয়ক this is the case on Thursday.
First, Lordship.
Okay, Friday some personal difficulties. Friday,
Monday.
Lordship.
much of 2007. Much of
Much of.
Okay, right?